ruling there. What distinguishes, leave aside the content of the affidavit, because that's a separate objection.
Understand.
What distinguishes that type of evidence from evidence, and assume for the time being that Mr. Godan will be required to come and talk to his evidence and be cross-examined. What distinguishes the first scenario from Mr. Godan putting the evidence he's going to testify to on affidavit and then leading that evidence?
Yes.
And I'm not talking of the content.
Understand.
It's a separate objection.
Well, unfortunately, you can't separate the two. But let me first answer the narrow question. The narrow question is, you don't ask the question like that. Etienne Murenik said that ours is a constitution of justification. In other words, when you are exercising public power, you must justify why you are exercising it. And again, that's trite law. Sorry. One of the newspapers thought trite is an insult. They said our submissions were trite. Trite simply means that it's law where you don't need to...
You can assume I'm alive.
You can assume, yes. Yeah. But the point is this. You can assume that you need to justify. That's the point I'm making. I'm saying, Mr. Godan, Chair, you can't have the Minister of Water waking up and accepting ambassadors. And he just wakes up. The point is made very nicely by Hoekstra at page, and I'll come to the narrow question. It's okay. It's in the.
I've seen that.
You've seen the passage.
If I understand the point, you're saying that if somebody doesn't have the power to take an executive decision or any other public decision, governmental decision, that person can't do so.
Yes.
I just want to ask a follow-up question, and then I'll keep quiet.
No, Chair, let me first deal with your first question, because otherwise
it flows from the first question.
Okay, fine. It's a follow-up. All right.
So, Mr. Godan, for example, could not exercise any powers now which the present Minister of Finance has, even though he was once the Minister of Finance. Assume, though, that using your example of the Minister of Water Affairs and the appointment of an ambassador, that the Minister of Water Affairs was once the Minister of International Relations, and an issue arises somewhere down the line, whether in court or in any other forum, a factual issue about whether a particular ambassador did something or did not do something. And that Minister now of Water Affairs has personal knowledge of those facts. Is your proposition or your submission that in order to testify to those facts, that now Minister of Water Affairs requires some power source in the Constitution or other law?
No. Then again, then
you've got to explain it. Yeah.
No, that's fine. Then, Chair, you're falling into the very trap that the President.
No, I mean, that's why I'm inviting you to explain
it. No. I'm distinguishing, and as I say, I tried. I put it I even underlined it in my submissions. I said, I'm not questioning Mr. Godan as a witness. I was avoiding this debate, but I have failed.
Okay, can I say that I'd like you to go through the debate? Because I've seen your heads of argument.
Yes.
And I'm grappling with it.
Yes.
So I need you to make...
No, fair enough. As
you
I say,
a fair hearing after all.
That's why I'm here. Yeah, that's why I'm here. If I was just happy with my written submissions, I wouldn't be here. Let's pause. The point I'm making is following. Start by the golden rule of the rule of law. If you are a public official, you may not exercise powers unless they are empowered by specific provision. Park that. Go to page 262 of Hoekstra, where she says, the general rule is that the power given to one administrator must be exercised by that administrator and not by some other unauthorized person or body. So underline unauthorized. When you say authority in this context, that's the authority we're talking about.
So what paginated?
I'm sorry.
number?
Oh, it's 201. 201 of our bundle.
Thank you.
Yes. So at the bottom, it starts at 200, the bottom of what I read, where it's the general rule, blah, blah, blah. Okay? So authority, when you talk unauthorized, we mean it in that sense, not in the sense of deposing. Yeah. If Parliament has chosen the Minister of Health, she says, to regulate the possession and sale of certain drugs, it would be unlawful for the Minister of Education to exercise that function. The Minister of Education would be acting contrary to Parliament's expressed intention by usurping the powers conferred on the Minister of Health. And the latter, by her failure to exercise the power herself, would be acting illegally. Whether one classifies the situation as usurping the authority or its abdication, the action remains unlawful. So whether you look at it as usurpation of the powers of Mr. Nene, as I will show just now, or the abdication of that authority by him, it remains unlawful. Or rather, usurpation by Godan and abdication by Nene, it would remain unlawful.
What again, leaving aside the content.
Now, so now I have three questions to deal with. I'm building up to answering your first question.
Sorry.
Now I'm getting to the third one.
I'm trying to ensure that as you answer that question.
Can I just answer it first?
But go ahead,
Yeah.
because I have a particular concern about what you're saying.
No.
I want to give you the chance to
That's
deal
fine,
with
Chair.
it.
Yeah. But let me, because as I say, I'm building up to the answer to your first question. So I don't want to owe you two more questions. My mind doesn't work like that. So the point I'm simply making at this stage is that this is this kind of authority that we're dealing with, and not the one that's answered by the president. Now let's come to your second example. All we are saying, and that's why I was saying you can't separate the content from the theory. All we are saying is that, of course, in your example, Chair, the Minister of Water, who used to, okay, let's use a concrete example. The current Minister of Land is Minister Maite Mashaban, and she used to be the Minister of International Affairs. So let's use her. She can't somewhere wake up one day, rock up at International Affairs and say, oh, I heard that Ambassador Mabuza is having disciplinary action. And when he was drunk at work in Canada, it was during my time. And so then I'm here. No. There are processes which must link, because the person who will be prosecuting Mabuza at that time will be the current minister, Minister Sisulu. And that minister takes her power from President Ramaphosa. So you are going to have to establish on what basis your only evidence suddenly comes from Minister Nkwana Mashaban. Not as a witness. Let's accept that she can be a witness. But you can't, in a constitutional democracy, simply rock up and do that. You're going to have to link to show the steps of how it is that Minister Nkwana Mashabane came to be the person upon whom the whole case, as in this case, depends, right? How do you do that? And that's why I'm saying that you can't separate the answer from the content. She would have to, even whether it's in writing or oral, is irrelevant for the purposes of this submission. But let's say it was in writing. She would then say, I am Minister Nkwana Mashabane. I used to be the minister. The person who's now in charge of this disciplinary inquiry is Minister Sisulu. or the president or whatever, they have asked me to lay down the lay of the land or whatever, simply because I was here at the time, blah, 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 blah. That's fine. There's nothing wrong with that. What I'm saying is that you can't do what Minister Gordhan has done. You can't come there and say, this is what he says. I'm the former minister. I served between 2014 and then in 2015 I was reappointed. I served in that capacity until 2017. I accordingly have personal knowledge of the fact relevant to this matter up until 30th March 2017. Let's just pause there. So he says he's got personal knowledge up until 30th March 2017. That is exactly a month between the time, not a month, a year, a full year, between the time he stopped having so-called personal knowledge and the time President Ramaphosa called Mr. Moyane and told him that he's suspending him for these charges. A year, full year. And in fact, President Ramaphosa was not even the president at that time. So that breaks any nexus between Gordhan and whatever it is that has made Mr. Moyane to be sitting in front of you today, right? And then he says, in respect of the period 31st March, I refer to confirmatory affidavits of officials and South Africans who had knowledge of the relevant events and custody of the relevant documents from that time. Well, firstly, okay, this is wrong for many other reasons, but the point we're talking about is that he says that he's going to rely on others. Firstly, those confirmatory affidavits were not supplied, and that's another point that we take, so let me get rid of it very quickly.
Have they now been supplied?
Well, they've now been supplied, but that's not a complete answer with respect, Chair. You can't, unless if you're going to run this inquiry on the basis that your rulings can just be ignored, well, then you must tell us, because we will do the same. Because there was a ruling here that said the affidavit, such affidavit as they supply must be done by the 22nd of June, right? By the 28th of June, when we sent you the objection, we had not received those confirmatory affidavits. Theoretically, then, for them, we were supposed to start the hearing. How are we going to start the hearing without those things? You've just put it on record correctly that only on the 9th of July were some of those affidavits supplied. And one of them even came now on the 18th of July with their heads. Nobody says to you, Chair, we couldn't find these people, they were overseas, please accept these affidavits. Nobody says to us that we should accept. It's just taken for granted that, you know, they are the president, they can do whatever they like. And they just put affidavits late, no asking for condonation. What would have happened if indeed we wanted to respond to this thing? We would have had to wait until this Wednesday before our time to answer kicks on. I mean, as I say, Chair, it's your inquiry. If you accept that, well, it's got nothing to do with me, but at least Mr. Moyane doesn't accept it. So
if I understand what you're saying to me correctly, on the point you raised in relation to paragraph 4,
yes,
you're saying that having regard to the time for the filing of the confirmatory affidavits, I should disregard it, and
yes,
I should determine your point on the basis that
yes,
it wasn't served.
yes, because nobody has asked you to accept it. No one. You may accept it out of the kindness of your heart, but no one has asked you. Then they say that, and then there's I can't put it lighter than this, quite a disingenuous point which is taken about the control of documents. The President says that, remember one of the points we're raising, and I'm doing this deliberately, Chair, to get rid of the smaller points. I know we're still on the question of authority. So I've now dealt with the confirmatory affidavits. I'm now dealing with the other question of whether the documents were in the lawful possession of Mr. Godan. Remember, we say those documents were not in his lawful possession. And the answer we have from our learned colleagues for the president is that, no, you must look at paragraph 3, where it says, these are documents which were in my custody and control during that time. That is just false. Because if you go, we must read paragraph 3 with paragraph 5. Paragraph 5 says, Godan says under oath, the facts contained in this affidavit fall within my personal knowledge. Alternatively, they appear from documents under my custody and control, or from copies of documents that I have seen. Right? Under my custody and control now, he says. Not when I was minister and so on. So you can't take us to that paragraph which talks about something else, and then you want us to ignore paragraph 5, which says that these documents are under his control now. They are unlawfully so. He should never have kept such documents if they were under his control as Minister of Finance, because he's now the Minister of Public Enterprises. There's a lot of work that needs to be done there. So the affidavit just betrays the unlawfulness of Minister Godan acting as he did. But so that deals with those points. So it deals with the 3 points. The affidavits were not there. The custody and control of the documents is couched in the present at paragraph 5. And in any event, the period from 30th of March 2017 then remains unaccounted for, to bring it to the nexus of Mr. Ramaphosa's actions of exactly 1 year later. But let's go back to the main point. The main point I'm really making, Chair, is that the sequence of the rule of law dictates that he would have had to explain here how it came about that between, and the other point that is made, which is really startling, is that there's no connection between the suspension and the reasons of the suspension, namely the loss of confidence of the president and the charges. I mean, honestly, I don't think I have to respond to such a submission, because the only reason that we're here is because Mr. Moyane was suspended pending a disciplinary inquiry, which is this thing we're in now. So I don't know how there can be no nexus between the two. But let's say that was just a moment. So the point here is that there needs to be a nexus. Remember, Mr. Moyane is here because the president says he lost confidence in him for whatever reason. And that's why he suspended him pending an inquiry into that issue. Now, Mr. Godan rocks up and gives evidence. His evidence must speak to the reason why we're here. And he must then say, and he could actually say this, Chair. In fact, I would never take an issue with it. He could say, the president has then on March 2018 asked me about some of the happenings while I was there, which the president would be entitled to do, by the way. And then on the basis of that information, he lost confidence in Mr. Moyane, and then he also, when it came to doing this affidavit, the president asked me, or delegated his power to me, or Mr. Nhlanhla, who is now the authority, the executive authority under which Mr. Moyane falls, was not here, unfortunately, when all these things happened. And one of them or both of them have asked me to put these facts. That would be fine. But, and obviously we would look at it on its merits here. But to simply just, without more, rock up, in a party to which you are not invited and run the show, I'm sorry, that's not the rule of law. All right? So, and he says, and let's make it even worse, Chairperson. The last, I'd like to use charge 4 as the best example of the point I'm making. Charge 4, you'll remember, is the one that deals with during the course, it's page 67 of the charge sheet. It's the thing about not attending, of the charge sheet. I'm sorry, of the affidavit. It's that thing about the so-called KPMG.
Can I ask you just to give me a moment? There's a note I want to make.
Okay, Chair.
Thank you, Mr.
Yes.
I wanted to raise an issue on the previous point you made.
Yes.
I think you were about to refer me to an example supporting the point.
Yes.
Let me raise it. You can then deal with it.
Yes, Chair.
If I understand you correctly, you're saying that there isn't a nexus between the powers of Mr. Nene or the President in relation to this inquiry and the evidence given by way of affidavit by Mr. Godan through deposing to that affidavit.
Not so much the evidence, the
deposing to the evidence.
Yes, the fact that it's Godan who's leading the charge. Yeah.
And I ask the question completely open-ended. What do I make about what is said in paragraph 12 of the affidavit?
1-2.
1-2 at page 4.
Yeah.
And then you can deal with it.
No, fair enough. Yeah. Yes, but that's actually the point. That point is actually a huge point against him in two different ways. Firstly, it betrays the fallacy of the retreat that was done in the terms of reference, going back to the previous point. Look at, you must read that point by reading 11 first. Then you'll realize that it's actually a ridiculous point that he makes. Paragraph 11 says, the charge sheet sets out the key averments in respect of each charge and stated the inquiry into Mr. Moyane's misconduct would be conducted on paper, and that an affidavit in substantiation of the charges would be delivered in due course. Right? Only then you must go to page 12. This is the affidavit envisaged in the charge sheet. Stop there. So according to him, this affidavit is the one envisaged in the charge sheet which outlaws oral evidence, to put the point strongly. All right? So firstly, this is the wrong affidavit. If that is the affidavit here before us, that is based on the charge sheet and not the terms of reference. It's based on the one that says it shall all, then Godan is wrong on that point alone. And then he says, its purpose is to set out the facts and evidence which form the basis of the charges against Mr. Moyane. But that doesn't answer the question with respect, Chair. That is its purpose. That we're not questioning its purpose, but questioning its deriving power and authority. Okay.
I've got that.
Yes, you got the point. Okay. Thank you. All right. So that paragraph actually kills them even more for two separate reasons, because it shows that this affidavit is unlawful because it's based on the wrong, sourced on the wrong power, and secondly, But that's a point, as I said, I'm not taking the point that there's a contradiction within the charge sheet and the terms of reference. I'm simply illustrating the point. And what makes that statement from Minister Godhan quite startling is the fact that at that stage, when he signs this thing, it's the 13th of June, 2018, long after the terms of reference have even been issued on the 3rd of May, or signed on the 3rd of May by President Ramaphosa. So it means he's probably never seen the terms of reference because he wouldn't base his affidavit on the wrong statute, so to speak. That is another incongruence that just makes this affidavit, not worth the paper it's written on. So to round off the point, we're saying there's no authority in the rule of law sense. There's no nexus between the March 2017 and 2018. The documents that he says he relies on are unlawfully in his possession. 4, he bases his affidavit on the charge sheet. And 5, which is crucial, it lacks, as we put it lacks the necessary amendments to connect it to either the president or Mr. Nene. It simply lacks those. And therefore, it's not worth the paper it's written on. And therefore, it's for those reasons incompetent.
Are you going to move on to your
Yes, I'm moving to the last point, yeah. But in any event, just in passing, Chair, just to illustrate this point, we all know that Mr. Godhan was a former commissioner of SARS. We all know that he has gone to give evidence in the Nuremberg Commission, which disparages Mr. Moyane's reign at SARS and makes his to look great. Now, all those are issues which, obviously, if he was here, we would deal with under cross-examination. To show, apart from anything else he says, that he is a biased individual, that there is hostility between him and Mr. Moyane, he's trying to rule from the grave as a commissioner of SARS, apart from his capacity as a minister. And again, that's natural. You know, somebody's successor, you always think you could have done better and so on. But those are legitimate issues that would be explored. How are we going to explore those? By looking at a piece of paper. We can look at a piece of paper until our eyes are red. Those are issues that necessarily will need to be dealt with under cross-examination.
Can I ask this question on that very issue?
Yeah. I'm sorry, Chair, if I beg you, can just say the last sentence?
I want to come back to this.
Yes. Just one sentence so that I finish the thought. Yeah. So what I'm really saying is that for a completely different reason, and I'm not going back to the first point, I'm simply illustrating that in this, remember fairness, as everybody says, is a matter of the particular circumstances. There's no generic explanation of fairness. It's like apartheid. You can't say what is apartheid. We can all give different explanations of what it is, but we know it when we feel it. So fairness must be judged in the particular circumstances. So I'm saying in the particular circumstances, knowing the personalities we're dealing with, that also emphasizes the point that this is not the kind of case where a person like Mr. Pravin Godhan would simply throw a piece of paper to us. We want him here. We want him to before he goes into the contents of this, to explain his bias, to explain his role, to explain the evidence he gave before Nugent, which was disparaging to Mr. Moyane, to explain his so-called operating model that he says Mr. Moyane changed and all that. So that as a witness, before Chair, you can even evaluate what he's got to say about what happened on this date or that date. And because we're going to argue at the end that you must either not put weight on his evidence or not put sufficient weight or discard it, depending on his answers, based on those questions. It's got nothing to do with the content, got nothing to do with the evidence, got nothing to do with the charge, got nothing to do with whether Mr. Moyane made this phone call to this one or that one. It's a matter that is central to this particular inquiry, simply because they've chosen, with their eyes open, Godan and not Nene, for example, or someone else to be the person. And that person has a particular history with Mr. Moyane. Yes.
Does that now not arise, and I'm not making any ruling on anything, but does that issue not arise, the issue of whether you test the motive, as I understand it, of Mr. Godan giving evidence? When Mr. Godan comes into the witness box and you're given, and if I give you the opportunity to
That's the problem, is the if in that sentence. There's no if.
If I can
Should
just
be not a question of if.
Can I just finish the proposition? And I say if quite guardedly, because assume you're right, and I'm not making any ruling with that cross-examination in the circumstances of this case being disallowed, either in entirety or for specific reasons, is completely incorrect, irrational, etc., etc. And if I make the decision to disallow cross-examination, is the point of challenge not at that point in time? By the same token, assuming I make the decision, because I'm enjoined to do it fairly or for whatever other reason, that cross-examination should be permitted in order to enable me to determine disputed facts. Does the issue arise at that point in time?
No. Let me tell you why. Ironically, the President's Council or the President has assisted us to answer that question. If you look at the case that they have cited called Matabate versus Nelson Mandela Bay Metropolitan Municipality and another.
Give me a second, let me just grab it.
Is it paginated? Okay, it's not paginated. Okay, their bundle is not paginated. But anyway,
which case number is it?
It's number 9.
It's number 9. Give me a second, let me go to that. Yes?
Okay, I'm not going to, you'll read it in your own time because it's not paginated. But
I've got it in front of me.
Okay, let me just tell you broadly what that case entailed. That case, they bring it here to try to say that oral evidence is not always necessary. But you can't bring cases like that case and the Bemau case of SABC case. Because in the Bemau case, for example, it was said that the procedure was a recommendation. That was in that case, it's that agreement between those people. Here, there's got nothing to do with this case. Here, there's no indication in what I read to you earlier that oral evidence is a recommendation. So that's mightily irrelevant. But helpful, thank you for putting it, because it helps us to answer your question. In the Matabate case, the employee went to the labor court and complained that he was not given an opportunity for cross-examination, and that because of whatever exceptional circumstances pertained there, the evidence was done in writing. The gravamen or the substance of that decision is the following. It says that employee, the labor court found against him. Why? It said, you should have raised that objection up front. Don't go to this is the thing that's in all the newspapers, which is supposed to be the great thing. No, Mr. Moyane is sabotaging his own inquiry, because he should just go to the inquiry as advised by the President. Go to the inquiry, let it proceed unlawfully, and then challenge it later. I mean, what is that? That case specifically says that if an employee does that, if it follows the advice of President Ramaphosa and his council, he will not receive any relief from our courts. Because the court will say, no, you can't come now, and you went through the process, you answered the charges, you put your affidavit, and now, because you have been found guilty or whatever, you come and tell us, I'm sorry, Mr. Court, it should have been oral evidence. No. That case says you must do it up front, and that is exactly what we are doing now. And it doesn't matter how many articles in newspapers are written or how many times it's put in the heads that we should wait and allow ourselves to be shot in the head on the basis that we will get brain surgery later. We're not going to succumb to that kind of nonsense. The point is that if we want to raise objections, you raise it now, particularly, Chair, as I've said earlier, when that objection begs the very question. In other words, we can't start, we can't move. We need to know what is this case about? Are we expected to bring witnesses, or are we going to bring an affidavit? You need to tell us. And if you tell us what we don't like, then we need to take it to court and challenge it. If you tell us that we must bring an affidavit, we'll bring an affidavit, or we won't bring an affidavit. If the court tells us, yeah, no, we must bring an affidavit, we'll bring an affidavit, or we won't bring an affidavit. But nobody has the right to tell us that we must go through and have our legs chopped up on the basis that we will get prosthesis. So that's the answer to your question. You can't say it must arise at that point. It arises now, both factually and logically. It must be answered now, because it must tell us what we must do next. Okay? Right. Now, so that's the second point. The third point...
Chair, I'm sorry to interrupt.
I'm
Before
sorry.
we get to the third point, would it not perhaps be appropriate to take a comfort break?
I was going to ask the question, how
Okay.
the comfort break, I think we should all get comfortable.
Thank you.
Can we resume at
15 minutes.
10 past till 11?
Okay. So this is the break we were going to take.
The break.
We just
and,
take it. Okay, fair
Mr.
enough.
Mpofu, I've seen your submissions
Yes.
on the third point.
I'll be...
Can I ask you to be mindful of time?
I will.
I want to ensure that
Yes, no,
Ms.
fair
Barnes
enough.
has a proper opportunity as well.
I will. And,
Thank you.
and if I overrun by too much, then it will prejudice me in the reply. I understand.
We'll resume at 11:10.
Thank you.
himself. He's hard worker behind, or he
Isn't
was.
it also an issue of costs containing, like
earlier.
But it's a question of I must decide on the nature of the objection and whether it's to be raised now or whether I can only determine when no, not at the end, when I know what's an issue. And that depends on me. But that's one of the points I've got to make a determination.
Moyane and his counsel will be saying, we want him here, you can't just throw papers at us, was the phrase. We'd like to have him here for cross-examination and interrogated what they've characterized as a bias on the part of Minister Kudar. What is interesting is that Mpofu has also taken issue with the timing of the affidavit, or an affidavit, I should say, from the presidency, and saying to Bham that he may not need to consider this affidavit at all based on the timing of it and the instructions that are absent from what to do with the information from that affidavit. So Mpofu not sort of pulling any punches when it comes to addressing how the presidency's council is approaching this matter. He was also very critical and disparaging of some media reports about this whole inquiry getting underway, and saying that they're right to be interrogating and questioning it from the get-go, because it's no good taking a shot to the head and then asking for brain surgery afterwards, saying it's no good letting your legs be broken and then looking for species later on. So really interesting and sort of featured phrase from counsel for the tax commissioner, or suspected tax commissioner, here at the inquiry, which is on a break at the moment, but we do hear that it will be getting underway again in the Not at all. I certainly don't know. Perhaps some other people here do, and I'll see what I can find out. But people are moving, and in fact, the suspended SARS Commissioner...
Can we get ready to start? Yeah. You've not been described as a snazzy person.
At least.
You're qualified. It will be the basis of my finding, one way or the other. No problem. Dali. Yeah, let's give it a limit. Can I just ask you this here? It'll affect you. I'm going to say the same thing to her. I know we're sitting next, each is extended session. We need a short outcome. Just, and if it's one of you, just motion to me and I'll do 5 minutes. I'll tell Heidi the same.
In fact, I'm likely to be the one. I'm just...
That's all right. Say the same thing.
Yes. What is it? Where's the NCA? Where is she? Is she outside?
Yeah, she's probably outside.
You must tell her my client is not Dan Moyane.
Oh.
She made a mistake. Yeah. I go to confidently. Yeah. Counsel for Dan Moyane.
Dan Moyane is at home.
Like, that's the joys of live TV. Yeah? I know.
Thank you. Are we ready to resume?
Yes, Chair.
Mr. Mpofu,
Chair, if I
just a
can just-
reminder on your time.
Yes, no, I'm quite aware, Chair. I'll be quite quick. Chair, the last point is about the parallel processes. And again, let's pause for a minute. On each of these points, we must pause to go back to the two pillars of what we're saying here: procedural unfairness and illegality or irrationality. So the first point was, the accent was on procedural fairness, and we explained that. That's the issue of cross-examination. The second point, the accent was on illegality with the Godan affidavit. And the third point basically covers both fairness and illegality. And I'll explain at the end. I'll make a statement, a broad statement that actually covers all the points in one long sentence. So what are we saying here? I've made all the prefaces about fairness must be looked at in a particular context. So let's just pause. We have a situation where the President of South Africa, Mr. Cyril Ramaphosa, appoints this inquiry, and then a month or so, or within a month or so, appoints let's call it the SARS Commission, under Commissioner Nugent. We say that emanating from the same person, being the President, who has appointed these two bodies, is distinctly unfair for various reasons. Again, I don't want to overdo the examples, but the example that comes to mind is the inquiry into the fitness of Commissioner Pierre. Fortunately, I took part in both the inquiry, the commission, and the inquiry into the fitness. Now, which the second one was called the Klassen inquiry. So if the Falam inquiry had happened at the same time as the Klassen inquiry, there would be something wrong there. So much as all of us wanted Commissioner Pierre to account and to be brought to book and so on and so on, we all understood that until the Commission of Inquiry makes recommendations that point in her direction, in fact, because of that rule, that's the price of fairness, she actually got away with it, because by the time the Klassen inquiry happened, and then she reviewed the thing, and then the contract had expired. But tough luck. You can't take shortcuts on the Constitution. So here we have a situation where the two things are being juxtaposed by the same president. But it's not just a matter of principle. In reality, what is happening is that at the same time as you will be sitting here, people are going to be going to the other commission and dealing with the issues that we are dealing with here. And making disparaging remarks in a public inquiry, in the public domain. And what's even worse is that, and that's not your baby, is that in that other inquiry, Mr. Moyane has been treated unfairly anyway. And it is
It's not something for me to inquire in.
Yeah, no, it's not. I'm simply painting the picture. And as... submissions. I'm sorry, Chair. I've just misplaced... Okay. Yeah, it's this one. I'm just saying as an aside, the rule against unfairness of those proceedings. Remember, we've also complained there about impartiality and conflict of interest. And it was in that context that we called that process a kangaroo court, which we repeat.
I think your heads call this one too.
No, no. Well, oh yes, we had the possibility of two. Yeah. Well, this one, the jury is still out. I think.
But if I understand it correctly, it's not an attack on.
No, it's not.
It's the structural appointment of two committees.
Absolutely, yes.
And that's the context in which.
That's the context. So it was misunderstood as if it was. We were saying all we were saying. That's why at paragraph 61, I put the dictionary meaning of a kangaroo court, which is any tribunal in which judgment is rendered arbitrarily or unfairly. That's what Collins English Dictionary defines a kangaroo court. And the Urban Dictionary says it's an unauthorized court which may be called a kangaroo court if its procedures are high-handed, irresponsible, and of doubtful legality, which is the principle we're talking about, the legality. So, but if one doesn't like that term, you can use the term that's used by Grogan in workplace law at paragraph 59 of my heads, where he says the purpose of disciplinary hearings is to ensure that accused employees have an opportunity to lead evidence in rebuttal of the charge and to challenge the assertions of their accusers before an adverse decision is taken. It is manifestly unfair if the decision is taken first and a sham hearing follows. So we can substitute kangaroo court for sham hearing because an author has used those words. So we call that one a sham hearing on the basis that it is there's bias. Whether that claim is right or wrong about the involvement of Professor Katz is something else.
But that's directed towards what you refer to as the SARS Commission.
Yes.
And as I said, that falls outside of my remit completely.
Yeah. No. All I'm saying, Chair, that's why I said in passing, is that in any event, even if that process was completely fair and so on, we would still raise this point. But I'm saying more so because we criticize it as being unfair in any event. But you don't have to find.
So I can't go into the more so part because
absolutely.
It's outside.
Let's assume it was prim and proper and there was no problem with it. We would still make.
I understand your challenge to go to the terms of the SARS Commission, the terms and what I'm dealing with in this DC, compare the two, and the unfairness issue you say then arises.
Yes. Yes, I'm saying the unfairness. The unfairness arises from. The unfairness arises from the overlap. Now, again, you get responses like, no, the other one is a commission of inquiry, and this one is a disciplinary inquiry. I mean, so what? That answer is a non-answer. It's an answer that you get, from the media and users of Twitter.
Have I been given the terms of the other commission to compare?
Pardon?
Have I been given the terms of the other commission?
In fact, Chair, to be honest, I assumed that they were before you, but fortunately they've been summarized in, we'll give you the full copy, but the relevant portions have been summarized in the submissions of the President.
I've seen that. Can I rely on those for purpose?
Yes, you can rely at paragraph 82.
There.
In fact, that's where I was going to take you now.
Thank
you. So I'm saying you can't, the President can come and tell us, no, this one is a commission of inquiry, the other one it doesn't make findings, and the other one is a DC. Of course, we know that. I mean, that's quite simple. The point we're making is simply that both inquiries are hit by Section 34, and both have a duty to be fair, right?
Section 34 of the Constitution.
Section 34 of the Constitution and Section 9 for that matter. And that proposition was clearly established in the case that is in our bundle of Makidiwana. And ironically, my learned friend, Ms. Barnes, was on the same side as me in that case. So I'm surprised that she has forgotten the case. That was established in that case. You'll remember, Chair, in that case, the issue was about legal representation. That's not the point I'm making. The point is that it was established in that case that Section 34 applies to commissions of inquiry and other tribunals which operate by the application of law. In other words, as envisaged in that section, Section 34. And another irony is that was also laid out in the case of Duprier and another versus Truth and Reconciliation Commission. That's Max Duprier, who I suspect also might have forgotten. In his case...
What's the citation? The
citation is 20...
Is it in the bundle? Give me the
no,
page.
It's referred to... If Chair, you go to page 123 of my bundle.
Give me a second.
1, 2, 3.
Thank you.
You'll see that case under paragraph 34. There's a reference to Groenling versus Van Rensburg and Duprier and another versus Truth and Reconciliation Commission. The citation is 1997-3, SA 204.
I've got that.
You've got it, yes. So, in that case, and ironically, remember that Truth and Reconciliation Commission was also an inquisitorial process. So there's no answer to say that one is inquisitorial, this one is adversarial. That's just saying nothing. Because in that case, it was said that the test is the following. And we quoted, Ms. Barnes and I, quoted this to the court. And this was sustained up to the Constitutional Court. This judgment went to the SCA and it went to the Constitutional Court and it was affirmed. It's at paragraph 35, and maybe this might also be a free education for those who make this distinction in the public space, including certain pseudo-professors. At paragraph 35, it says, the Chief Justice cited with approval Lord Denning MR in the English case of Re Pegamon Press Limited, which concerned the procedural and investigative inquiry conducted by inspectors in terms of the Companies Act of England, obviously. Lord Denning said the following, because he was faced with this thing that, no, the one commission doesn't decide anything. He says, it seems to me that this claim on their part went too far. This inquiry was not a court of law, another famous thing, that we don't understand the difference between a court of law and these proceedings. It was an investigation in the public interest in which all should surely cooperate as they promised to do, like this one and like the Nugent Commission. But if the directors went too far on their side, I'm afraid that counsel for the inspectors went too far on the other side. You can supplement the counsel for the president. He did suggest that in
I think I've got the point that she appeared.
point of law, yes. He submitted that where there was no determination or decision, but only an investigation or inquiry, the rules of national justice did not apply. I cannot accept that submission. It is true, of course, that the inspectors are not a court of law. Their proceedings are not judicial proceedings. They are not quasi-judicial, for they decide nothing. They determine nothing. They only investigate and report. They sit in private and are not entitled to admit the public to their meetings. They do not even decide whether there's a prima facie case. But this should not lead to us to minimize the significance of their task. They have to make a report which may have wide repercussions. They may, if they think fit, make findings of fact which are damaging to those whom they name. They may accuse some, they may condemn others, they may ruin reputations or careers, The report may expose persons to criminal prosecutions or civil actions. And then, and it was said that because of that, if you look at paragraph 36 of what our court said here, says, of course, these went in the context of the procedural fairness inside proceedings or committees or commissions and so on. However, I can see no reason why they should not be applicable with equal force to a case such as the present, where similarly the rights of persons, including those of the applicants, are potentially in danger of infringement. The common denominator is the recognition that committees and commissions like the Marikana Commissions have the power to make far-reaching findings and recommendations which carry potential prejudice to the rights of individuals and corporations, the bearers of which are entitled to protect even at the investigative stage. And it says, in LAWSA Volume 2, the position is neatly summed up as follows. The argument that the recommendations of a commission do not affect existing rights because they decide nothing in themselves has been rejected. It is now accepted that serious repercussions can flow from report of a commission. For example, very damaging findings of fact could be made in respect of people who are named. In addition, a commission's report may accuse or condemn persons who may then be subject to civil or criminal proceedings. So this popular thing of saying no, which was repeated by Judge Nugent, that no, this is a commission and it's just investigative, flies against the provisions of our law. The fact of the matter is that an investigation such as this one, which applies law, and such as his, which applies law, must, in terms of Section 34, be run under the rules of fairness, which is what we're coming to assert here. And naturally, it must also be run under the rules of rationality. And as I say, that principle was established in the Dupree case and was affirmed by all our courts. And okay, I won't read, I'll just refer you to paragraph 37, 40, and 42. Are also relevant. Paragraph 47, 50, where it says the Commission is a public inquiry operating under considerable local and international scrutiny, and the outcome thereof will have potentially massive ramifications for individuals and so on.
I'll read this paragraph.
Yes.
Just give me the paragraph.
Okay.
50 and which is
37, 42, 47, 50, 51, 52, yes, okay. And 59 for what is worth. The starting point being paragraph 34.
I've got it.
So what is the point that we're making? And again, we make examples and then we're told, no, when we talk about lis pendens, res judicata, sub judice rule, and all those, these are simply examples. What we're saying, we're not saying these things apply here directly. We're saying those are rules based on fairness, all of those rules. The media knows even better the one called sub judice, that you don't report about a fact, that a case that is still pending. All those rules are rooted in one thing and one thing only, fairness. The res judicata, double jeopardy, lis pendens, those are all rules of fairness. And they simply say you can't be treated. And the answer that we're given is not an answer, because they point out, and this is from the code, they say, for example, it happens that an employee might be charged in a disciplinary hearing, and they might also have a criminal case at the same time. Sure, that is so. But that is not what we're talking about here. If you have a disciplinary case, you are charged by your employer, and if you have a criminal case, you are charged by the NPA. Here, you are charged by the same person, the president, gives you this process and another one at the same time, and holds them like this. It's a completely different situation. And in that other process, you are not, well, firstly, you are aggrieved because it's a sham proceedings or a kangaroo court, but also you are not properly represented. Now, with the greatest respect, I don't know if the Nugent finding is in front of you, Chair.
Not to my knowledge.
No, okay. But okay, we'll supply it to you. I challenge you, Chair, or invite you to make sense of what he says on this point. I can't.
I'm not going to deal with it because it's outside of my remit.
No, you might have to, if you allow me. Remember that this point this is the one point that really crosses both commissions necessarily. So you can't ignore the fact that that other commission is there. That's what we're discussing. So we raised this and we said to him, okay, here's he went on in his ruling that, no, I can't stop this, it's the president and so on. But actually we had offered a way out. We said, okay, you might not want to stop these proceedings, the SARS Commission, but give us an undertaking, it's a letter which you'll find, give us an undertaking that you will not cover the same ground that is being covered in the commission until in the DC, until the DC is finalized. Very reasonable proposal from Mr. Moyane. And as I say, Mr. Nugent said, the Commission is capable of carrying its work for a time without covering the ground that might be covered by the disciplinary inquiry. Lest it prejudice, I think he wanted to say prejudices, lest it prejudice the work of the disciplinary inquiry, I do not intend to do so at this stage. That's completely good. I don't know what it means. But whatever it means, at the end of his ruling, he says he's turning down all our requests. So we can assume that it means he's not acceding to the way out that we offered him.
Will that be made available to me?
Yes, certainly.
No
certainly.
findings.
Just for that paragraph. It's paragraph.
Not even, yeah.
Yes. In fact, I can end it up now.
And can I just make it clear, in receiving it, I'm making no finding on whether I can refer to it, and if I do, to what extent. I've heard your submission, and
that's correct. Or whether it's good or bad. No, absolutely. That's not your place, Chair. That will be decided by a court.
The paragraph in the ruling that you've just referred me to?
The first paragraph is paragraph 26.
Ms. Barnes, you do understand, I'm making absolutely no finding. It's been referred to in argument, and on that basis I'm receiving it. But I
Yes.
give consideration.
Yes, thank you, Chair.
Thank you. You say paragraph 26, Mr.
26, Chair.
Okay, page 8.
20.
I've got it.
Yes, you've got 26.
Nonetheless, I'm aware of the charge.
Yes, nonetheless, whatever. And as I say, it's completely meaningless. Yeah. But the only way you can read it is to look at paragraph 38, which is the last, page 12, where it says all the rulings and relief sought by Mr. Moyane are refused. So I assume, therefore, that other indecipherable stuff means that he's not accepting the proposal. Yeah. So that's really all we were saying. Don't run another commission which overlaps with this one, and I'll come to that just now, Chair, the extent of the overlap, because that's important.
You'll be mindful of time as well.
Yes, I will be. All right, let me go there directly, Chair. This whole submission as to whether Mr. Moyane is being disparaged and all that can only work if we can show you that there's an overlap between the two processes. And that's why we dealt with that specifically in our heads. And of course, the answer to that is not the standard thing of, no, the other one is a commission, the other one, we know that. The issue is whether there's an overlap. And the overlap, at least one of the highlights of Judge Nugent's ruling is that he accepts that there is such overlap by merely saying one of the ways would be to not to cover the ground covered in the commission. He acknowledges that there is an overlap. And then even the president seems to accept the overlap because he says that his paragraph 88. We point out that it will frequently be the case that individuals are legitimately subject to overlapping legal processes. So they also accept that there's an overlap. But they then give the wrong answer about criminal charges and so on. Now, where is the overlap? Chair, all you have to do, you know the charges, I won't go there. just go to paragraph 82, and of the heads of the president. And again, I won't develop this because of time, but it's self-evident. And if you tell me there's no overlap between these two processes, then my name is not Darling Wolf.
I won't make that fine.
Yes, I will. Otherwise, I will withdraw it. Let's go to paragraph 25. The whereas, okay, the first one, tax is a crucial basis and so on, that's fine. Then it says, and whereas the significant revenue shortfalls in 2 consecutive years, 2016 to 17, and projected for 2017-18 are identified as key fiscal risks and a factor in South Africa's credit rating. Now, that's exactly what is said was caused by Mr. Moyane. That's exactly what Mr. Godan gave a 140-page presentation to show about his wonderful operating model. Happened under it and so on. So there's a clear overlap between that and here. It says, and whereas in VAT and other refunds from part of a systemic policy to reach revenue targets, taking account of the findings of the Office of the Tax Ombudsman. Okay, this might not be in front of you, Chair, but for what it's worth, when we do lead evidence or in whatever form, you will remember that the so-called VAT refunds allegedly to the Guptas and all that, were part of the reason why he was suspended by the president. It was part of the outburst that was made to him. So it may or may not come under the charges.
Hey, I'm sorry to interrupt, but my learned colleague is not permitted to give evidence. His comment now about the outburst has never been placed on earth, and is evidence that he's impermissibly attempting to give from the bar.
Can I just say this? I'm going to decide the matter, as I said at the outset, on the issues. In the interest of ensuring that we finish the hearing.
Yes.
I'm not going to interject, but I do want the parties to understand that I'll confine my mind.
Yeah.
to what is
My learned
conversation.
colleague could just be cautioned not to give evidence.
I want the hearing to finish, but I'll confine myself to what is relevant.
Well, Chair,
Mr. Mpofu, I don't want to...
no, I understand that, but let me just say this, please allow me. That is very rich coming from the President's Council, who has put in her heads, given you evidence of what Gigaba said about this, what what is it? Yes, that the commission, or the SARS Commission was started because Minister Gigaba and Mr. Moyane accepted it, and here's the press release. They've put all that, and now they've given evidence in their heads of argument, and now they want to lecture us about that, please. So the point I was making anyway is that the VAT issue is part of the overlap. But it's not necessary. You can find that one is not before you, as I acknowledged here. And then they say, go to the next one. And whereas certain practices in the tax system have undermined taxpayer morality and confidence, that's exactly what it is said in the other commission is Mr. Moyane's contribution to SARS. And then, and we can jump the other one. The administrative provisions and so on, that's neutral. Then and whereas the reports in the public domain that potentially undermine taxpayer morality need to be assessed for the veracity thereof, and possible corrective measures need to be implemented to maintain taxpayer morality and confidence. That's exactly Mr. Moyane's, what he's being accused of doing. The so-called reports in the public domain are these things about Makwakwa and this and the other one, which is part of the charges. The main charge in front of you is about that. And corrective measures that are spoken about can mean nothing else but what you are doing now, that are envisaged there. And the next one, and whereas deterioration in revenue collection transparency of the fairness of tax administration present a threat to fiscal sustainability, service delivery of the public, and the continued deepening of our democratic gains. That's exactly what Godin says before Nugent we are guilty of. And then it says, then the Commission of Inquiry is tasked with inquiring into making findings. Remember the Magidiwana case? Remember Lord Denning? Reporting and making recommendations in respect of a wide range of issues relating to tax administration and governance at SARS. So anybody who can tell you that, and of course, and Commissioner Nugent makes the point fairly. He says that his commission covers a wide scope, and this one covers a narrow scope. Of course. But, you know, when I did arithmetic, you don't worry about the two sets. It's the intersection between the two that we're worried about. So it's the overlap, not the space that is distinct on the others. And only a person who is not from here will say that that overlap is not coming out distinctly from just those terms of reference. So the point is very simple. You cannot have a process where two public processes in respect of which in the one you are being disparaged about the same or similar issues that are in the other process. So
it's ask you to wrap up.
I'm sorry.
Otherwise,
sorry. No. I know. I'm okay. Let me wrap. I will.
You've got another 3 minutes.
No, okay. The point. You've got the point, Chair. It's the overlap and the parallel processes and basic fairness. Let me do this in wrapping up, because this point really covers all the 3 points. This is the irony of ironies. And it's a demonstration of irrationality. If irrationality is called illogicality and something that just doesn't make sense, madness, basically, then this will demonstrate it. And it runs through the three themes. Minister Pravin Gordhan, who's a key player in both parallel inquiries. Remember, he gave evidence in the other one as the main witness as well, in which we contend he has no basis, according to the rule of law, or no business to meddle in, was prepared to give oral evidence in the inquisitorial process of Commissioner Nugent, but refuses to give oral evidence in the adversarial process before Bham SC.
But why do you say he refuses to?
I'm saying because he told you at paragraph 12. At paragraph 12 of the 11 and 12 that his affidavit is the affidavit envisaged in the charge sheet, which says that there's no oral evidence. I'm simply saying that he is prepared. Okay, you can call it whatever, conditionally, what. But the point is that in the first one, he gives oral evidence willingly. And that's the one where there's no need to give oral evidence because it's inquisitorial. There's no, it's an investigation. This one, which is adversarial, where he should be giving oral evidence because the statutes and the contract and the Constitution compel him to do so, he won't give oral evidence. Now, if that is not a sign of irrationality, nothing ever will be. It's just doing the one thing when you're supposed to be doing the opposite. The only example I could think of was it's like wearing your pajamas to work and your suit to sleep. Where you're supposed to be doing A, you do B, and or giving an obituary at a wedding and proposing a toast at a funeral. It's just madness. It's completely illogical. If he's prepared to give evidence in the inquisitorial post, it should be an a fortiori proposition that in this one where it is adversarial, it should follow as a night follows day that he should also give oral evidence, or vice versa. So that I'm just saying that picture, if you really look at it in your mind, of someone who gives oral evidence in the inquisitorial one and not and want to give an affidavit in the adversarial one, is the starkest illustration of the irrationality and the unfairness that we're talking about. If anyone says that is fine, actually that's how life should go under a constitutional democracy, well, then, Chair, it will mean, yes, it will mean that you'll then have to find against us if that isn't really what is envisaged. And but if you agree that oral evidence is prescribed in the as you must in the disciplinary code, if you agree that there's no justification for Mr. Kodan's affidavit and that there's no nexus between it and the other one, and if you agree that the parallel process in terms of the Magidwana case is potentially, at least potentially prejudicial to Mr. Moyane, then you'll have no choice but to uphold all the three objections. Thank you.
For your reply, and I don't want you to go into it now, you'll address whatever else you want to address, but can you address me on what I do if I'm with you and what I do if I'm against you?
Yes. Thank you, Chair.
Thank you. Ms. Barnes, you've waited patiently for a while. You've heard the points I've raised. I've read your heads of argument. I'm not going to restrict you. I'll allow the flow, and when I say something, it's particularly because I need assistance on it. I've got no views formed as. Thank you.
Thank you, Chair. Yes, I intend to start with a question that you raised early in the proceedings this morning, and that was whether you, in fact, need to decide the nature and or extent of Mr. Moyane's, I'll refer to it as his entitlement to pre-dismissal fairness. Are you, in fact, required to decide the nature or extent of that, given the terms of reference? And the answer, Chair, is a resounding no. The terms of reference are clear, and as we will demonstrate in our address, they are entirely lawful and fair. This means...
Does it go to all 3 points or the first point of
this?
This
goes to the first point. Yes. And so the first point, which my colleague, Mr. Mpofu, indicated this morning, is in fact the main objection, is entirely without substance, because the terms of reference are clear, they're lawful, they're fair. Now, I do need to deal in my submissions to some extent with Mr. Moyane's entitlement to pre-dismissal fairness, simply in order to demonstrate that the terms of reference are lawful and fair, and I do so only for that purpose. Now, let's take a step back and look at what Mr. Moyane is actually seeking in relation to this main objection. He is seeking a determination by yourself, Chair, that the procedure prescribed in the terms of reference is unfair, unconstitutional, unlawful, and apparently for good measure also manifestly oppressive. Now, with great respect, Chair, you simply have no power to make such a determination. You are bound to run the disciplinary inquiry in a manner that is fair and just. And we've repeatedly heard that that is all that Mr. Moyane asks for, fairness and justice. And there it is. The terms of reference require it. We submit, Chair, that Mr. Moyane's first complaint, or his main objection, it effectively assumes that you will not conduct the inquiry in a manner that is fair and just, despite being entitled and, in fact, enjoined to do so in the terms of reference. And a number of things flow from that. We submit there's no basis whatsoever for that assumption. We in fact, take exception to it. But it's for that very reason, Chair, that these proceedings are entirely premature. And as you have indicated this morning, you've asked the question to my colleague on a number of occasions, is this not premature? Because you simply haven't yet made decisions about whether and to what extent oral evidence may form part of the inquiry. Clearly it may be.
The argument, I think, is that I shouldn't be given the discretion because of the code, as I understand the argument. I'm not saying I'm agreeing or disagreeing. If I understand the argument is the prematurity point is responded to by suggesting
we'll get
that
to
I
the
should
code.
not have the power to do so.
We'll get to the code. But what we want to say at the outset is that, firstly, The determination which Mr. Moyane seeks in relation to the main objection is not legally capable of being given.
That goes to my power, you say.
Yes. And secondly, and in any event, it's not necessary. It's not necessary because the terms of reference require the inquiry to be fair and they don't exclude oral evidence. So what I propose to do now, Chair, is unpack our response to the main objection.
Just on the first point,
Yes.
sorry, the first of the point you make, as I understand it, where you say that I don't have the power, you're saying that because I've been appointed and I've accepted the appointment by the President, to the extent that there's a challenge to what the President has framed, that's a challenge that's going to be directed to the President, not to me.
Indeed, Chair.
Is that the point you make?
You're bound by the terms of reference. You may act within the scope of the terms of reference. There's no authority upon you
I understand the
to find
point. I just want to...
that the terms of reference are unfair or unconstitutional or unlawful or manifestly
You're not
oppressive.
arguing there's no other revenue. You're saying that's something to be dealt with by the framer or the author
Indeed,
of
indeed,
the Commission and the terms.
indeed. That would be correct, yes. So what I propose to do now, Chair, is to unpack our response to the main objection in a little more detail by posing and then answering two questions. The first question is, what is Mr. Moyane entitled to in terms of pre-dismissal fairness? And the second question, which I'll ask and answer, is what is he getting? So let's start with the first question. What is he entitled to? Now, we say in the first instance, we must start with the power. The power to discipline and dismiss Mr. Moyane is an executive power in terms of Section 6 of the SARS Act, which is held by the President. So the question that must be asked then is what is required for the exercise of that power in order for it to accord with the law and the Constitution?
Ms. Barnes, can I, and I promise you I'm going to leave you to flow I just want to ask a question up front so you can pick it up in there. I've gone through the heads on the point, and there's fairly eloquently and well set out. Whether I agree with it or disagree is another issue. You make reference to the presidential power. Work on this, assume that is correct in law, and I emphasize assume, there's no finding on that. To what extent does it arise in this matter? Because the President has chosen, in this particular matter, not to go down the route you say he could otherwise have gone. The President has chosen to go down this particular route, which is the charge sheet framed as it is, coupled with the terms of reference. Mr. Mpofu's main line of argument to that question was that the terms of reference don't go far enough because they dilute the code.
Chair,
Without wanting to cut you off, what I'm really concerned about in relation to the argument...
I'm not going to go. I'm going to get to the code very, very shortly. And I
the
simply
terms
need
of
to
reference.
start, it's important that we start with what Mr. Moyane is, as a matter of law, entitled to, because it is, frankly, not very much. And I need to deal with the Msetla judgment because my colleague dealt with it, but I'll deal with it very briefly. It's not necessary to go into great detail. The Msetla judgment makes it clear that all Mr. Moyane is entitled to here is, in fact, a decision that is lawful and rational. Msetla does remain good law, contrary to what my colleague has said. My colleague referred to the Albert judgment. We submit with respect that his reading of the Albert judgment is not correct. It is not sufficiently nuanced. What happened in the Albert case was that an entitlement to procedural fairness was found to arise out of the rationality requirement of the rule of law. But it was not found in Albert that there is a self-standing entitlement to procedural fairness as part of the rule of law in the context of the exercise of executive powers. That was not the finding of Albert. And so Msetla stands. What we have in fact done, Chair, and I'll hand it up perhaps at the end, if necessary, is that we have noted up Msetla, and we have a summary of all the cases, including Albert, that have followed Msetla, and this makes it absolutely plain that Msetla is still good law on the point of executive action, particularly the power to dismiss, and what is required in order for that action to be lawful. And I'd like to quote briefly from one of the cases that refers to Msetla. It's a very recent case, It's Minister of Home Affairs and another versus Public Protector. It's not referred to in our submissions, but I did alert my colleague to it yesterday. But it's a 2018 SCA judgment, 2018 3SA 380 SCA, where the court was dealing with the grounds of review that arise under the principle of rationality versus the grounds of review that arise under PUDGA. And it said the following, I quote, "The only difference in the grounds of review I can discern at present is that those exercising executive power have been exempted from the duty to act fairly." And it then cites Masetla. So that's the SCA in 2018 confirming that Masetla is indeed good law on this point. Now, our opponents say,
One more
Yes.
question. Sorry, Ms. Barnes, but if I allow it to go with my own mind being cleared up, I may make mistakes in whatever I decide. That would be in the context of the President exercising a particular prerogative power, such as, for example, dismissal. And that's the context in which you've raised it. So assume the President had decided, as opposed to suspension, to dismiss Mr. Moyane at the outset. There might have been a fight, there probably would have been a fight about whether he acted properly, whether he was required to act procedurally, fairly, and the like. What's being tested here is the President exercising his power, in this case, in a particular manner. And that manner is through the terms of reference read together with the Charter.
But Chair, the starting point is that wasn't required. All that was
I
required.
understand that starting
Yes.
point. What you're saying to me is he's been given more than he was required to give.
Yes.
Ergo, what he's been given, he should be happy with, and there shouldn't be a complaint. Something along, I'm putting it colloquially, but something along those lines. What I'm concerned about is the challenge is to whether what he has been given.
Yes, and that's what I'm getting to.
And that's what I want
Yes,
to deal with.
yes.
Because it seems to me that once you say to me that I'm a creature of the terms of reference, any complaint about it, whether it's good, bad, or indifferent, I've got to deal with by reference to what I've been given, not by reference to what the President might otherwise have done.
I'm getting to the disciplinary
Thank
code
you.
right now, Chair. I just needed to set out the starting point in law as to Mr. Moyane's entitlement here. So our opponents say, the disciplinary code, the disciplinary code. This entitles Mr. Moyane to procedural fairness, and as we've heard, they refer extensively to Clause 10 of the disciplinary code. Now,
Can I accept that the disciplinary code does apply to Mr. Moyane?
no.
Thank you.
So the first point is that we say, this, as we can see from its face, it's a collective agreement between SARS and the trade unions. We say that this document cannot bind the President in the exercise of his executive powers. But before we all become very concerned, I can see my opponent looking very concerned, Chair, in this case, it doesn't make a difference. So we don't concede that it applies. We say this document cannot conceivably bind the President in the exercise of executive power. But in any event, it makes no difference. And I'll explain now why it makes no difference. It all turns, Chair, on paragraph 5.1 of the code, which has been referred to by my colleague, but he seems, with respect, not to have appreciated its import. This is the paragraph that deals with the scope and application of the disciplinary code, and it says the following. The disciplinary code and procedure applies to all employees of the South African Revenue Services, and then this is the key sentence. Should circumstances dictate, the employer may decide to follow a different process for management unit employees, which process will be fair, just, and aligned with the principles of the Act and the Code of Good Practice on Dismissal. Now, this is precisely what has happened here. And as my colleague has pointed out, this paragraph is mirrored in the terms of reference. The terms of reference require a process that is fair, just, and aligned with the principles of the Act, of course, being the LRA, and the Code of Good Practice on Dismissal. Is Mr. Moyane a management unit employee? Clearly. This is a case where the employer, being SARS, has decided...
I'm sorry, I don't know where that comes from now. I thought Malene Tran said we mustn't give evidence.
She's arguing a point.
Okay.
I want to raise a question, Ms. Brown. You're correct. Let me make the assumption. Standing, and Mr. Mpofu will deal with it. It says for management unit employees, the qualification at the very beginning of the sentence says, should circumstances dictate, which would suggest to me that in order to exclude management unit employees, circumstances must so dictate. And I don't have anything before me which deals with circumstances which may have dictated the exclusion of management unit employees from the code. And my concern at the moment on what you're submitting to me is whether or not I can rely. You may have other points, but on the point you're making, whether I can rely on the second sentence without any factual reference to circumstances so dictating.
Well, Chair, it's apparent from the terms of reference themselves.
Give me a second. I just want to get your submission of this. You say it's apparent from the terms of reference.
Yes. So it's apparent from paragraph 2 of the terms of reference, which indicate the particular circumstances in existence here. And it says the following: the inquiry into the disciplinary charges against Mr. Moyane must be conducted urgently in the light of the critical revenue collection role of SARS, the need for public confidence in SARS, and stability and certainty in the leadership of SARS, and the broader risks that SARS poses to the fiscal framework and budget, which may impact negatively on South Africa's investment grading and cost of capital, and on the capacity of government to fund service delivery. So those are the...
Well, you see, that's exactly my concern. You saying to me that those are the circumstances. The clause says, should circumstances dictate, the employer may. Now, at the end of the day, it seems to me, on the face of it, and I'm open to persuasion, but on the face of it, that it's the employer who is required on a set of circumstances which the employer thinks so dictates to exclude the operation. Now, I understand your first point is that the President is not bound by this in any event. Your second point, so I'm either with you or against you on that. Your second point then refers to the code to show why, in relation to Mr. Moyane, and you referred to him as a management unit employee, the code should be excluded. And I'm going to ask on what basis I make the finding. You refer to para 2 of the terms of reference. And my concern is just that may, on a matter I need to make a finding on, as opposed to a fight between you and Mr. Mpofu on other issues, you may be inviting me to make a finding on its applicability on a factual basis which is not before me.
Well, Chair, with respect, there are two answers. The answer is that the employer is entitled, in respect of senior employees, to adopt a process that differs from the norm. There is that entitlement. So that's the first answer. It's a legal answer that arises out of the code itself. The second answer is that...
I'm assuming that you're right on that.
Yes.
I'm now asking for the factual basis to show...
The factual basis is the basis that is set out in the terms of reference that indicates that there are very serious considerations here having regard to SARS, to its critical revenue collection role, to the need for stability and certainty, and for those reasons this inquiry must be conducted as a matter of urgency. Those are the circumstances. They are absolutely plain from the terms of reference. And it immediately follows from that statement that the inquiry must be fair, just, and aligned with the principles of the LRA and the Code of Good Practice. So immediately after setting out the particular circumstances which exist here and the need for urgency, there's a reference to paragraph 5.1 of the Disciplinary Code. The two follow each other and are inextricably linked. Paragraph 3 of the terms of reference then goes on to set out a process which starts with the exchange of documentation. So, Chair, we submit that all that then needs to be decided is whether what is being done here in terms of the procedure is in fact aligned with the LRA and the Code of Good Practice. And there, what's critical to note, and we've dealt with it in some detail in our submissions, is that neither the LRA nor the Code of Good Practice entitle Mr. Moyane to a hearing with oral evidence. And I'd like us to go at this stage, Chair, to our submissions.
Which paragraph?
To page 10. There we refer as the starting point to the Code of Good Practice, which does not require a hearing with oral evidence. And, Chair, Mr. Mpofu has referred to, he's used the term a formal hearing, as if a formal hearing somehow includes oral evidence. That's not correct. There's no link between a formal hearing and oral evidence, and the case law makes that absolutely plain. So the requirements for a hearing in labour law are set out in the Code of Good Practice. They are essentially that the employee must be given notification of the allegations against him, and that he must have an opportunity to respond thereto, that he must have a reasonable time to do so, and that he may be entitled to assistance in that regard. We deal, Chair, at pages 11 and 12 with the Avril Elizabeth case, which makes it very clear, paragraph 35, in reference to the Code. When the Code refers to an opportunity that must be given by the employer to the employee to state a case in response to any allegations made against that employee, which need not be a formal inquiry, well, there we have it. Whether it's termed formal or informal is neither here nor there. The point is that the requirements for a fair hearing are set out in the Code. We continue with that quote. It means no more than that there should be a dialogue and an opportunity for reflection before any decision is taken to dismiss. And then on the next page, Chair, page 12 of our submissions, we deal with the case of the SABC case, which we cite in paragraph 37 of our heads. And here, my colleague referred to the fact that the procedure set out in the disciplinary code here was merely a recommendation. But he stops there when he ought to have, with respect, gone further, because the Labour Court found in the first instance, it said, well, yes, it is only a recommendation, but in any event, the court found that it couldn't be said that this was an informal hearing just because there was no oral evidence led. There was no oral evidence in this case, but nevertheless, there was a hearing chaired by an independent chairperson on a panel of a respected dispute resolution agency. There was a hearing on paper without oral evidence or argument, and that satisfied the requirements for a fair hearing, as set out in the Code and as clarified in the Avril Elizabeth Home judgment. So, what's important about that case, Chair, is that the court said that it wasn't correct to say that was simply informal, that it satisfied the Code and it was sufficient. Very important, Chair, is the next case that we refer to in paragraph 40 of the heads of argument, where here an employee was dismissed following a disciplinary hearing conducted by way of written representations only. And the court, the employee approached the Labour Court for orders to declare the termination of her employment unlawful and the disciplinary proceedings against her a nullity. And here, Judge Van Niekerk in the Labour Court dismissed the application and said the following. In my view, the applicant was afforded a right to be heard on terms that satisfy the requirements of the Code of Good Practice. She was afforded an opportunity to state her case, which she did with the assistance of counsel. The chairperson considered the submissions and made a decision. He communicated the decision to the applicant. The judge then went on to say, this is not the first time that a disciplinary process involving the submission of written representations has received judicial sanction. That is a process that complies, I'm paraphrasing, with the Code of Good Practice, and there was therefore no breach of contract or any unfairness. So we say then, in summary, Chair, that what the President has afforded Mr. Moyane is a process that is fair, just, and in accordance with the principles of the LRA and the Code, and that process does not entitle him to oral evidence. But in any event, Chair, again, the bitter irony is that oral evidence is in fact not excluded.
Before we go to that point, I think your submission is on the basis that I'm with you on the second sentence of 5.1. In other words, the first submission on the code is that the President is not bound by it. The second submission is if the President is bound by it, 5.1 allows an escape because of circumstances. Assume the code does apply, and I want to cover all bases so it assists me when I finally decide this. Assume it does apply. What do I then make about Mr. Mpofu's clause 10 submission? When I say clause 10, the different submissions in clause 10. You may want to interweave it in your other argument, but just bear that in mind when you deal with it.
So I didn't quite follow,
So
Chair. The last question
The
was?
last question is, assuming if your second submission is that even if it applies, even if the code applies to Mr. Moyane, clause 5.1, the second sentence of 5.1 gives the out, and that I can read the circumstances from and link it to the terms of reference because of the wording. What I'm asking is, just assume for the time being that I've got to deal with what Mr. Mpofu argued, that it does apply to its full extent, and it sets out procedural matters in clause 10, the sub-paragraphs of clause 10. Deal with it should you wish to, but it's one of the points that he's raised, and it's something I may have to give consideration to. I don't know whether I need to, depending on your first 2 points, but I may need to. I
So
just
the
don't know.
question, as I understand it, is in the event that 5.1 does not apply, what is our position?
Yes,
Is
yes.
that,
In relation to
is
the
that the
code.
question? Okay, I will get to that. Thank you, Chair. So we have in our submissions referred to the terms of reference and what they permit. It's not necessary to go there in any detail. We've also referred to the charge sheet and what that provides. If I can just take you there, Chair,
To the charge sheet.
to our submissions where we deal
Oh,
with
yeah.
the charge sheet.
That's at page 15.
Yes, page 15, paragraph 46. Now, we make the point in our submissions that it does not follow from what we've stated here in the charge sheet that oral evidence would not be permitted under any circumstances. And of course, the charge sheet and the terms of reference have to be read together. They were prepared together and submit. There may have been a day or two in between, but they were submitted together. And we make the point that if Mr. Moyane and his team were confused and thought that this meant, just notwithstanding what the terms of reference say, that there could never ever be oral evidence under any circumstances, then it was clarified as far back as the 15th of May, when we wrote a letter and said, in the event of any disputes of fact, this is on page 16 of our submissions, the process to resolve such disputes can be determined by the presiding officer, including referring the issue to oral evidence. And then in the next paragraph of our letter, oral evidence is therefore not precluded or prohibited in the inquiry. Your client is not precluded from making submissions to the presiding officer for oral evidence to be heard, and the nature and extent of possible oral evidence will be determined by the presiding officer. On the 15th of May, so we've adopted a process that starts with the submission of affidavits, which is provided for in the terms of reference and the documentation that is relied on in support of the allegations made in the affidavits, and we then envisage a procedure where, in the event that there are disputes of fact, they may be referred to oral evidence, and that is a matter that will be decided by the presiding officer, as you are entitled to do in terms of the terms of reference. There is absolutely nothing unfair in that procedure. It is permitted by the disciplinary code in the event that that is applicable. It is permitted by law, and it is in fact more than Mr. Moyane is entitled to. Moving then to the second complaint relating to Mr. Gordon's affidavit. We've dealt in some detail in our submissions with all these sub-complaints here, and I don't intend to traverse this complaint in any great detail. Frankly, the first complaint in relation to the first sub-complaint in relation to Mr. Gordon's authority is, with respect, bewildering. There's no need or requirement for Mr. Gordon to have any authority to depose to an affidavit as a witness. You asked the question, Chair, this morning, but if Mr. Gordon if we were running the inquiry on the basis that witnesses were being called to give oral evidence, would Mr. Gordon need any authority to come and give oral evidence to the inquiry? And the answer is obviously no. The fact that his evidence here is given on affidavit does not change that simple fact. So what our opponents have obviously done is they've confused the authority needed in order to institute proceedings and the giving of evidence. An authority is required, well, the one must be authorized, the one may amount to the exercise of public power. Here we're dealing with Section 6 of the SARS Act. And we know that that power is held by the President, and we know that the President issued the charge sheet, and we know that the President issued the terms of reference. But that is the institution of the disciplinary proceeding. The giving of evidence is a separate matter where no authority is required. So that's the confusion that underpins this complaint. And we set out the cases in our submissions which address that. In particular, the case that we refer to on page 18, from the bottom of page 18 of our submissions, Gaines versus Telecom Namibia, where the court says the deponent to an affidavit in motion proceedings, and these are of course court proceedings, not as here, the deponent to an affidavit in motion proceedings need not be authorized by the party concerned to depose to the affidavit. It is the institution of the proceedings and the prosecution thereof which must be authorized. Chair, in relation then to the matter of the confirmatory affidavits, we make the point the confirmatory affidavits were filed late, and it will be seen that the majority of the confirmatory affidavits were in fact signed and commissioned at the same time as the main affidavit, and there were some logistical difficulties in this regard, and we can certainly put that under oath and apply for condemnation if necessary. But the irony, Chair, is that there's no prejudice here to the other side because they're not answering to the substance of the allegations. And they've made that very clear for many weeks. We've known for many weeks that there's not to be any substantive answer to any of this, that they're merely technical points to be raised. And so the fact that the confirmatory affidavits have come late in these circumstances has not prejudiced them in any way. Then, on the matter of Mr. Gordon's affidavit, we've also dealt in some detail in our submissions with the complaint that the affidavit lacks the necessary averments to sustain a cause of action, I believe is the terminology used, although that's not entirely appropriate given that we're not in court. And again, with respect, we find this a bewildering complaint.
It's framed as it lacks averments.
Yes.
To link it to what? they define as the central issue being the alleged loss of confidence. So in other words, if I understand the complaint, and as I said, I'm going to look at it in substance as opposed to form. If I understand the complaint, there isn't any link between what Minister Godown says in his affidavit and the President's loss of confidence. Now, you do deal with it in the heads, but if I understand it, that's the point that has been raised.
Yes, of course it's changed slightly. I mean, in the notice itself, there's a reference to the President's loss of confidence. In the body of the submissions, there's a reference to the irretrievable breakdown in the relationship between the President and the Commissioner, which are, of course, two different things. And we make the point that the loss of confidence was the basis of the decision to suspend. That decision was taken some time ago. It stands. There's never been any attempt to challenge it. It was wholly unnecessary and frankly would have been inappropriate for that matter to have been traversed in the affidavit in support of the charges. The purpose of the affidavit in support of the charges is simply to set out the facts and the evidence upon which the charges are based. Whether the loss of confidence was ultimately justified, it will be a matter that will be determined at the end, depending on whether the charges are proved, which is an entirely separate matter. As far as the breakdown of trust is concerned, that is a matter that may be relevant to the inquiry into sanction, but has absolutely no relevance to the inquiry at this stage. That is whether the charges have been proved on a balance of probability. So in relation to that, we say that may be relevant later at the sanction stage. In relation to the loss of confidence issue, that has no relevance to the charges and whether the charges are proved.
And then the documents in the possession of Mr.
Yes,
the way the point is framed, yes.
Yes, the correct position is, as we have set out in our submissions, we set out the paragraph in our submissions where Mr. Gordon says he has the basis for his deposition to the affidavit is his personal knowledge and his knowledge of documents, some of which he's had sight of in the past and some of which were within his custody and control in the past during the relevant period. I'm paraphrasing, but that's essentially what he says.
I think what Mr. Nkofu referred to is what is said in paragraph 5. And he set that up in contradistinction to what is said in paragraph 3.
Mr. Chair, the correct position is what is set out in paragraph 3. And then, Chair, if I might then move on to the third complaint.
Yes.
And here, Chair, we would...
This is the parallel process.
Which is the parallel processes. And here, Chair, we would...
Chair, I don't want to interrupt my learned friend, particularly since I have a right of reply. But I need to make it clear now that we will not accept her giving evidence about that you must choose paragraph 3 over paragraph 5. That needs
I think I've said it at the outset that I think the parties must accept that when I decide this matter, I'll do so on the weight of what I'm permitted to rely on, what I'm not.
Yes, thank you.
I haven't interrupted
Just
you on
want
that
to-
particular issue, and I'm not going to interrupt.
Just to record it, yes. Sure.
That doesn't mean
No,
that I
no.
made a decision on her submission.
No, I'm also not asking for
But I
a
think
ruling.
you need
I'm
to
simply
accept
placing it on.
for the flow of the argument. I'm not going to quibble with parties on those issues because at the end of the day, it's for me to make a decision on the weight of the
Yes.
submission.
Thank you.
That's fine, sorry.
In relation to the parallel processes point, Chair, here we wish to start where we ended our written submissions with a simple point that you as the presiding officer of this disciplinary inquiry are obviously not empowered to make any determination pertaining to the fairness of the two processes together, let alone to make some sort of order which would either stay or disestablish either one of the processes. We simply don't know in what legal world our learned friends think that such a determination or order would be legally competent. Clearly it would not be. All that you are empowered to do, Chair, is to conduct this disciplinary inquiry in accordance with the terms of reference. And that should really be the end of that complaint we submit. But in any event, our opponents have failed to demonstrate that there is any unfairness, because they simply say this. They say the simple fact of the two processes being in existence at the same time, and the fact that Mr. Moyane has a role to play in both, is unfair. But they do not explain how, and with respect, they cannot. In our submissions, we deal at the outset with the nature and purpose of the two processes. And we do so in order to give the lie to this narrative that we've seen this morning, and that's also emerged through the media, that these things have been set up together in some sinister way, masterminded by the same people. But the point is, we know that the Commission of Inquiry into SARS was being talked about in 2017. It was called for by then Minister Gigaba.
I want to, on this
How
issue
do we
again,
know that?
if I can just...
So
in the same way as I did the previous. We aren't going to permit things without interjecting, to the extent that it's close to the bone of what I need to decide on. I think the party should be aware that I'm going to determine it purely on matter before me, and not on what's in the process. It's quite important for the parties to understand it, because that takes me out of a comfort zone of what I can rely on and what I can't rely on.
We simply make the point, and just to round off the point, that the origin and purpose of the processes is entirely different. The fact that there may be some overlap is neither here nor there. Our opponents have to show that the two processes being in existence at the same time, and the fact that Mr. Moyane has a role to play in both, is somehow unfair, and they cannot, with respect. They refer to lis pendens. It's not a situation of lis pendens.
No,
There's no legal proceedings that are...
It's fairness at the end of the day. It's not the classic lis pendens.
Sorry.
But with respect, they need to have... They can't simply throw up their hands and say...
I understand that submission.
We don't like it, we think it's unfair. There must be a legal basis to challenge it. If they say that you, Chair, somehow, on some basis that we cannot fathom, have the authority to rule that the two together is unfair, or to disestablish or stay one of the other, then there must be a legal basis. And all they do is they say, well, we use lis pendens and res judicata and double jeopardy as examples. But where is the legal basis? There is none. And we know, Chair, we've pointed out in our submissions that it will often be the case that individuals will be subject to overlapping processes. And there's nothing inherently unfair in that. When an employee, one thinks of the example of an employee in an internal workplace disciplinary inquiry facing charges of fraud, and the same employee being subject to criminal charges of fraud. Those processes overlap. There's nothing unfair in that. And that's not even an apposite example here, because we know that the Commission of Inquiry is inquisitorial, tasked with fact-finding only, and that this process is adversarial, charged with making findings of guilt or innocence. And the important point about that is that there's no risk to Mr. Moyane of being... He cannot be charged in the other Commission of Inquiry. That commission is not empowered to level charges. He cannot be found guilty of anything in that Commission of Inquiry. That is not its purpose. And so the argument becomes even weaker when one considers that this is an adversarial process and that is an inquisitorial process only. So they cannot show any unfairness, even if they could. You, Chair, are simply not empowered to give them the relief that they seek. Just one other point. I'm done. If I could just go back to the first complaint and just...
You will, before you
There's
finish,
something I omitted to say earlier in relation to the first complaint.
deal with that and
Yes.
don't omit what I asked Mr. Mpofu at the end. What do I do if I'm with you and what do I do if I'm against you?
If I can go back to the first complaint, I needed to make reference to my colleague's submissions in relation to Section 34 and Section 9 of the Constitution, the right of access to courts and equality, respectively, which he submitted in the vaguest terms with respect that somehow Mr. Moyane is relying on these, and somehow these give him a right to oral evidence. I mean, every individual has those rights. How those rights give Mr. Moyane a right to oral evidence in these proceedings is unclear, and frankly, they don't. Chair, in relation then to your question, our position is simply that in the first instance, the code does not apply. And we must remember, Chair, that we're dealing with an unusual situation, one that is perhaps sui generis in the sense that the Commissioner is appointed by the President in terms of the SARS Act. The Commissioner then performs services for the institution, but the power to appoint is here an executive power. And we submit that this collective agreement cannot bind the President in the exercise of that power. But
Can I make a determination of that issue without some form of evidence? I am a bit concerned that I've been presented with a code, circumstances of its production, other than what Mr. Mpofu had to say, a document having been furnished by the State Attorney, not fully canvassed. How significant it turns out to be, I don't know, because I've got to give it consideration. And I'm addressing myself to both parties. I didn't know, Mr. Mpofu, whether there was an issue about it or not until Ms. Barnes raised it. But how do I simply on paper, or on the papers before me, make a decision one way or the other on that?
the reason it hasn't been canvassed in the submissions was because it hadn't... neither side canvassed
I
it in the
understand
submissions.
it.
And
In the light of that,
and
what do I
it
make of
hasn't
it all?
been.
Yeah, what do I make of it all?
But
If it
we-
becomes critical that I make a finding on it, what do I make of it all?
But we say it's self-evident that a collective agreement can't bind the President in the exercise of his executive powers. We say that's absolutely self-evident. It could not be otherwise. But in any event, if we're wrong and it does apply, we say that we've given Mr. Moyane what he's entitled to in terms of 5.1. That we're entitled to do. We've explained in the terms of reference why we've done it. And what we've done complies with the LRA and the code, which is what 5.1 requires. And we say 10 does not apply. There's no application in this case. And we're not required to conduct an inquiry in accordance with 10 because 5.1 allows us not to.
And if it does apply,
Well, we submit that it doesn't. Chair, I may have omitted to answer your question in relation to relief, and perhaps
Yeah.
I think my submissions are clear in relation to what you should do if you're with us.
you're obviously not going to tell me I must be against you. I'm
but-
saying that
But
it's postulating either
in
situation.
relation to we submit that the complaints are obviously without merit and must be dismissed, and in the event that it's necessary to. In terms of the further conduct of the inquiry, we would submit that you should order, Chair, that a written response to the affidavit of Mr. Gordon be filed within a particular time period. And you could also, though it wouldn't be strictly necessary, but you could also indicate in your ruling that the parties are at liberty to make submissions in relation to oral evidence that should be heard, and that you'll make a determination thereafter.
And if I'm against you, I know your submission is I can't be against you. But that's not the purpose
Chair,
of my
we
question.
we submit that there simply isn't the legal authority to make the determinations sought by our opponents, and so we couldn't possibly make submissions in the nature of a draft order
No, I'm not asking for a draft order.
or anything along those lines, because we say...
I understand. If I'm with you,
isn't the
you've given me a
authority-
way forward. If I'm against you, I'm on my
isn't the
own.
authority.
What
What I might
understand
submit-
that. Okay. Now, I'm not pushing you. I've given you the opportunity.
What I
So
would
you
submit
decide.
in relation to Mr. Gordon's affidavit is that even if there were arguably some merit in any of the points raised by our colleagues there, it doesn't follow from any of the points that they've raised that the affidavit is rendered inadmissible. We know what the test for inadmissibility is in law. We've set it out in our submissions. We've referred to the standard that must be met for striking out. It's scandalous, vexatious, and so on. No such case has been made out. Well, no case, let me be clear, no case has been made out for striking out, and no case has been made out for inadmissibility. And so, in the end, even if there were arguably to be some merit in any of those points, they don't take us anywhere. The affidavit stands.
Thank you, Ms. Mans. Mr. Mpofu, do you want to take a 5-minute break?
Yes,
and
that
can we then try-
looks like we're doing well.
We'll get back at 1:45. And
But I'll try.
latest 1:15. I'm sure you'll try to give us a break before that.
Yes.
Yes.
I'll try.
1:45. Thank you.
Thank you.
And then after, I'm going to give this.
No, I'll see
Yes.
I'll work over.
Rub the salt in
Yeah.
Just remind.
It refers to the period of 2014 to 2017. It's towards the end.
So since 2014.
To 20, yes.
Okay.
Whatever that paragraph is, yes. I just wanted to, just to round off the point of overlap. So that's the period, exactly the period of Mr. Moyane's tenure at SARS, which is ongoing. Now, coming back to the reply, I'm going to try to be quite fast. The first point that was made, and I know the chair has been, to both of us, has said, look, irrespective of what the general legal principles are, am I not guided by the terms of reference, which is true. But for what it's worth, I simply want to say that to argue that Masetla is still good law on this point of procedural fairness not being applicable is just to deny the obvious. And my learned friend says I'm reading the law wrongly on that. Well, I'll say I'm in good company because Professor Hoekstra also says that Albert Center in the study of violence, the minority approach in Masetla of Ngobo gained supremacy. And the same judge who had since become a Chief Justice took up the same theme, this time with the support of all his colleagues. In other words, the full Constitutional Court subsequently. That's what I was taught in first year, that the rule of stare decisis. The later case is the one that is the law, not the earlier case.
But I can read the judgment to the nota up, read
Yes.
and I can
Absolutely.
to the extent I need to.
Yes. You don't even need to, Chair, because, again, Professor Hoekstra has been kind to you. At page 420, she says, at the end, as I have suggested elsewhere, it is difficult to think of a decision whose rationality would not be enhanced by an impartial hearing on both sides. And this gives huge scope for the development of the procedural fairness requirement identified in Albert. Furthermore, there is nothing to stop procedural fairness from being acknowledged as an aspect of lawfulness in the appropriate cases, or more simply as an independent requirement of the principle of legality. So, so that submission...
I only get involved in that debate depending on what I find on the four corners of the terms of reference.
Yes, absolutely.
If I find that they're inherently fair in and of it, then I don't have to go into the debate.
Yes.
Of course, you want me to get into the debate for a different reason,
Yes.
but you accept that depending on my finding on the terms of reference.
Yeah. No, that I accept. It's called judicial economics. You don't have to decide something you don't have to decide.
And I think all judges follow.
Yes. If you find that the four corners are sufficient.
Thank
But
you.
for what it's worth, if ever that this goes to any other stage, then those niceties might be debated there. Now, the most startling proposition which was made is that the question, are you entitled to decide the nature of the fairness in this matter, must be answered by a resounding no. But how can that
Chair,
be
I'm
so?
sorry to interrupt. That wasn't the submission.
Well, I wrote it verbatim.
Can I say this? I've given both of you the opportunity. I think at some point I would hope that you trust me to know what your submission was.
Yes.
It's also being recorded and I'm going to get a transcript.
Thank God.
And if there's an incorrect premise, then
The submission related to the legal basis.
I'm not going to allow debate between the parties. You made your submissions,
It's
and
fine.
I'll discern what was the submission and what
Yes.
wasn't the submission.
Thank you, Chair. Well, I wrote it verbatim. It says, are you entitled to decide the nature of fairness? The answer is a resounding no. But if that was not the submission, then I'm happy because then I'm no longer startled.
I've got the transcript available to me, and
Yes. Yeah. Anyway, whatever the wording is, the proposition that was made is that you don't have the power to decide this question. That, in whatever language, is just, then I'm startled again. Because the terms of reference make it, they say, A, that the hearing must be fair, must, it's an injunction. And then at 3H, it then says you must determine the ambit of that fairness. And at 3K, it says you have a discretion on matters to do with oral evidence.
but then your submission must be a fairly narrow one. I don't mean meaningless,
Yeah.
I mean narrow. And that submission must be that in relation to the terms of reference, I'm given the discretion to determine fairness.
Yeah,
But your complaint is that I'm given such a discretion in light
Absolutely.
of the code.
absolutely. Yes, I'm saying as it stands now, yes, that's correct.
You're not suggesting that you can make any submissions on whether I've made a decision of fairness or not, and something I've done is inherently unfair.
Yeah.
You're saying that the mere fact that it is left in my hands
Means you have
troubles
the
you
power.
legally.
Exactly. You have the power. How
I
you
understand it's
exercise...
not troubled about me, it's troubled legally because of the...
Absolutely, yes.
And so it's limited to that issue.
Yes, absolutely. Okay, then I'll move on. So it's very clear that the terms of reference gives you the power. I might disagree with how you exercise it.
But
It's a different matter.
the submission by Ms. Barnes, I hope I get it right now, is that on the question of whether being given the discretion, and because of the discretion, there's an inherent unfairness, I don't have the power because I'm bound by the terms of reference and to act. And if there's going to be a challenge, and I think I asked the question, that's a challenge that must be directed way above my pay grade.
No, yes, no, there are two issues here. One is you have no power to change the terms of reference. That must be very clear, because the change of reference are not your terms of reference. So, for example, you can't unappoint yourself, and nobody has asked you to disestablish anything. I don't know where that comes from. It must be coming from television, because we haven't asked you to disestablish anything. So that's the one thing which is obvious. But don't make the same mistake that Commissioner Nugent made, which is that your hands are tied, because your hands are not tied. According to Commissioner Nugent, he gave what I call the Nuremberg Defense. He says, if the president says I must do it, I must do it. So if the president says, yes, Mr. Katz, I must accept him. Even if I could see him taking a bribe in front of myself, I can't do anything. Or in your case, even if somebody comes here and the cross-examination is clearly inapplicable, you must just say, well, the president said this, and so on. That's surely that's not the point. The point we are saying is that even on the terms of reference that are before you, you are given a discretion. A discretion is just a power. It's the same word. Once you are given a discretion, then it means you are given the power to decide on the fairness. So you could say, for argument's sake, you could say, I don't want oral evidence, 0. Or I want 100% oral evidence. So you've got that discretion.
But you say it's the discretion that causes you the problem.
Yes.
And Ms. Barnes says that it's not within my remit, it's within the president's remit to be challenged on the fact that I have that discretion. But if I understand it, if I could just take it a step further, it doesn't seem to me, though, that the moment you consider that my being given the discretion is a problem, that I can utilize that very discretion in order to decide the broader point. That's not what you're saying.
No, that's not what I'm saying. What I'm saying is very simple. I'm saying that the president, remember, let's assume, let's take it to the other logical. Let's say we went to court, and we'll go to court and say, Chairperson Bham should not have that discretion. The court will obviously say, well, you should have raised that with Chairperson Bham, because according to this terms of reference, he could make a ruling that says, in my commission, or whatever, in my inquiry, I will only take 100% oral evidence. Now, once that is so, then we have to start here, because it would be premature to go to the
But aren't you
to the
running
court.
two arguments, not in parallel, and again, I'm putting the question so you can assist me on that. Aren't you crossing two arguments? Because if I understand the first point you make, it's that the president has given me terms of reference,
Yeah.
which don't give you a right to cross-examination, but which gives me a discretion to give you that right. And because the president hasn't given you the right, there's a problem with the terms of reference.
Yeah, of the president.
And of course, Ms. Barnes's response to that is any challenge to that must be a challenge to the presidency, not to me.
Yeah.
The second argument you're running seems to me to then hoist the very discretion you take issue with as a basis upon which I can determine the prior point. And that's the difficulty. If I've misunderstood your argument,
Yeah,
please,
you have.
please clear me up.
No, you have. You see, that's exactly what the law, as explained in Rule 65D3, is what we are explaining here. Whether we accept that this is not a court and so on, we're simply saying that that's the right that we're exercising. The law in Rule 65D3 says, under normal circumstances, you get an affidavit, right? A founding affidavit. And then you normally would have to do what they call is pleading over. In other words, you'd say, I'm raising my points in limine, and then, but this is what I say on the merits. That's the normal way in which an answering affidavit is. But Rule 65D3 gives you a special dispensation, which is what we're exercising here, where you say, I am only raising the legal points for determination, and those legal points must be determined upfront, because if they're determined in my favor, I might not even have to go further than that. It's that simple, yeah. So you are here. We accept that you are appointed de facto. The fact that the appointment is valid and that you are given certain powers, but we're saying that within those powers, you could make this determination. In fact, you could. That's why I'm saying you could make it to our satisfaction, quite frankly. So you could say, yes, I agree with you, Mr. Mpofu, and going forward, all evidence will be 100% in terms of the disciplinary code. And if there are any issues that both sides are agreed on, you can record them as put up in paragraph 10. And that will be the end of the matter. So
I just don't understand it. Are you saying...
It's only if you couldn't do that I wouldn't...
Are you saying that if I were to find that
the code
in
applies.
the exercise of my discretion... Now, I've got to frame this carefully because I think this may be the area of problem.
Yeah.
If I were to find in the exercise of my discretion, and I want to move away from the labels of motion proceedings, that anything that is put in issue, however it's put in issue, I don't want to dictate how that would be, would require cross-examination, or I have the power to determine that. What would your position be there?
No.
And that's what I'm concerned about.
Yeah,
because it
no.
seems to me you're giving me the comfort of a discretion and you're taking away.
No. Actually, this is very simple. If you go to the notice, that's why we put...
Your notice.
Go to the notice itself, you'll see that the notice envisages this, and it's actually very, very simple. Look at page 3 of the notice, where it says, kindly take further notice that the Commissioner hereby specifically reserves all his rights at a subsequent and appropriate stage to deal with and respond to the allegations contained in the affidavit of Mr. Pravin Gordhan, all of which are for the avoidance of any doubt hereby denied and disputed in toto. Okay? So you must work on the basis that there's no room, as we speak now, for any motion proceedings. Okay? Now, if you rule that because of that, then we should go into the mode that is explained in the disciplinary code. Then the next thing that will happen is that we will then invoke section 10.3. Okay, that section that says...
But by reference to that or the terms of reference?
Yeah.
Assuming at some point the issue becomes an issue, and it may now be that. In writing, it is placed on record, and that's the response to the affidavit.
Right.
That everything in there is disputed. And I say that whatever is disputed is the subject matter of Yard, is the subject matter of cross-examination. And of course, if you say everything is disputed, then whatever covers everything.
Yes.
So I'm just battling
You
to
are
understand.
capable of making that order.
Yeah.
That's all I'm saying. I'm
And
not saying...
if I'm capable of making that, do you still take issue with the fairness of the proceedings at a broader conceptual level?
Yes, because by doing that, you will be, in effect, expanding the scope, the limited scope that you have now been given. And Mr. Moyane will be very happy and grateful to you. And the disciplinary inquiry will start tomorrow. He'll call his witnesses. They'll call their witnesses. Yeah.
That's it. But then the argument goes the full circle. However I exercise my discretion, even if you're happy with the exercise of discretion, is not the issue. It's the fact that I have a discretion.
Yes.
So the argument goes the full circle.
Yes, it goes full circle. Okay. Thank you. Yeah. So to argue that your hands are tied, a la either the Nuremberg Defense or this, because of the terms of reference, is just wrong, plainly wrong. Yeah. So the terms of reference, I mean, as everyone has been saying, my learned friend says, the terms of reference don't exclude oral evidence. Just by using that double negative is exactly what we're complaining about. We don't want terms of reference that don't exclude oral evidence. We want terms of reference that say that there must be oral evidence, and only by exception, if there are agreements as usual on this and that point, then obviously you don't have to prove something that like the examples I was making for emphasis, his name and what.
But on that very point, Mr. Mpofu, sorry, if I have to keep you a couple of minutes longer, I just want to get clarity on the point.
Yes.
If that then is a challenge, not to my discretion, that then is a challenge to the existence of the discretion, which was given to me by the President.
Yes.
And then is it within my remit to determine powers that were determined or that were imposed on me by somebody else?
No. Chair, okay. Let's take one step back. You see, unfortunately, we are in what's called Hobson's choice land.
I know. That's why I'm trying to get
Yes.
commissioners to help me out.
So,
of it.
yes. So if, let's take a wild example. If, for example, you say, no, between the code and the terms of reference, I'm choosing the terms of reference. I'm likely to challenge you in court on that ruling, okay? Theoretically, if you say the opposite, that no, the terms of reference, I'm widening the scope to 100% oral hearing, the president is likely to challenge you on the basis, and I'm using this just as a theoretical.
I don't know that. But there's a third option, of course. And the third option is that I could find that in reading the terms, assuming the code applies, I don't know whether I can make that decision,
Sure.
but assuming it is, I've got to read the terms together with the code.
Absolutely.
In other words, that legal principle that you try to give meaning where meaning can be given. But
Yes, absolutely.
So in other words, it's not binary. There's
No.
a third
It's
choice.
certainly not binary. And in fact, actually, the answer, that's why I'm a little bit, I want to move on, because the answer lies in what you had said earlier, which is that all these niceties about the terms, the scope of your power and so on, the bottom line is the code. If the code applies, then you are simply bound by it anyway. Let me tell you why. I mean, it's actually, I'm afraid, if there's the president who said this must be said, well, then it's his problem. But you can't come here now and say, and want to run away from the code, disciplinary code. I mean, that's just really not acceptable.
How did the code come about in
Yes,
these proceedings?
I'll explain to you just now. I'll start again. Mr. Godan, right, says at paragraph 26 of his affidavit that Mr. Moyane is bound by the South African Revenue Service Code of Conduct. This thing.
Give me a second.
Right?
Yeah, can you just give me 1 second? There are 26 or 27, you said?
26 to 30. All right?
Yes.
Okay. So that's beyond anybody's dispute. So,
Now, is there anywhere in the affidavit where he identifies specifically the document he's referring to?
I'll assist you. Okay? So, Godan says this code of conduct applies. Go now, take the code of conduct. This is the exercise I went through this morning. Go to 3.1.5.
3.1.
0.5, yeah, page 48.
The code. Oh,
The code, this thing.
okay, just tell me where I
That's
find
the one in the bundle, in the...
Oh, yes,
yes.
sorry, the legislation part.
Yeah.
Give me a second. Carry on, sir.
Right.
What do you want me to go to?
Okay. Then Mr. Godan says this thing is binding on Mr. Moyane. I read it, we read it, and we come to 3.1.5. It says, any SARS employee who contravenes or fails to comply with any provision or standard of the code will be subjected to the SARS disciplinary code. Okay? Then I phoned Mr. Mabuza. Mr. Mabuza, please can you phone Mr. Chowe to please give us that SARS disciplinary code that is referred to there. Mr. Chowe sends the disciplinary code to Mr. Mabuza, this one that is now being disowned by the president. All right?
I object to that, Chair. It's not being disowned by the President.
Well, okay, the one that allegedly doesn't apply now. He said, Mr. Chowe, the state attorney, sends us the disciplinary code that doesn't
Try and
apply.
keep your submissions accurate.
You know, I'm not,
Listen
I
here.
certainly am not going to...
I'm telling you verbatim what actually happened.
Can I just say this? Place what you want to place on record. Ms. Barnes, if you want to respond to it, you can do so. I'll give you the opportunity.
Okay.
What I'm not going to allow
Yes,
is for counsel to talk across the table. I'm chairing the hearing.
Please.
And I will, for as long as I'm empowered to do so, do just that.
That you are empowered to do, even under the current terms of reference.
Can you continue? But I'm not going to permit counsel to talk across the table or past me.
Please, no, it's fine. I don't mind.
And if you want the opportunity, you'll have the opportunity, Ms. Barnes, to respond.
Yeah. Chair, I promise you what I'm telling you, Mr. Chowe,
Make your submissions, and
Mr.
if Ms.
Chowe
Barnes
is here and Mr. Mabuza is here. They will tell you that the document was asked for 2 or 3 days ago. The disciplinary code, Mr. Chowe sent it to Mr. Mabuza. As soon as Mr. Mabuza received it, I said to Mr. Mabuza, please send it to the chair and to Ms. Barnes. Even though it comes from her attorney, I still said send it to her. So we sent it back to the people who gave it to us, this disciplinary code, which we are told today doesn't apply. Right? And so, I honestly, it's disingenuous, to put it bluntly, to come and say this disciplinary code doesn't apply by the same people who gave it to us. Okay, but let's say I'm wrong again. Well, if I'm wrong, Chairperson, I'm asking now, the next 2 minutes, that the President must give us a copy of the SARS disciplinary code that is referred to at 3.1.5 of the code of conduct that Praveen Godan says applies here. We want it. So if it's not this one, that they gave
Chair,
us
can
2
I
days
just
ago.
respond to that so that we can try and get this inquiry finished? We
I
have
think Mr.
time
Mpofu is
constraints.
finishing. Yeah, Mr. Mpofu is finishing his
We have
submission.
never suggested that this is not the SARS disciplinary code. I'm not sure where that comes from.
Okay,
So you can accept that this is the code and move on.
Thank you very much. Okay, thank you.
Can I just place that on record?
Please, I think we've made a ruling about talking across the table.
I'm going to, Mr. Mpofu, if I understand it correctly, the SARS DC code, which is referred to in 3.1.5
Is this document?
of the South African Revenue Service Code of Conduct, which is referred to in paras 26 to 30 of Mr. Godan's affidavit, is, as I understand what Ms. Barnes has said to me, the document that you made available.
Thank you.
Yes.
Yeah.
Thank you.
Now-
Okay, that's the end of the issue. Can we move on?
Right, thank you very much. Now, if that is so, then we go to that document, because they gave it to us because it is that document that we are told by Mr. Godan, if you don't apply this code, we will be punished in terms of. So let's go to the punishing document. So the punishing document then says at 5, this disciplinary code and procedure applies to all employees of SARS. All right? Mr. Moyane is one of all employees of SARS. Okay. So that's the first point. Then it says, should circumstances dictate, the employer may decide to follow a different process for management unit employees, which process will be fair, just, and aligned with the principles. And I'm not going to argue that point, but whether, let's say for argument's sake now, he's in the management unit, he's a management unit employee.
Carry on.
Yes. Then the point becomes, okay, what are these circumstances that dictate that a different process should apply? In fact, that part doesn't even say a different process. It says a fair and just process, which is what we were crying for. Okay? So this argument is completely irrelevant, because once we establish that he is one of all employees, once we establish that this is the code that applies, then the question becomes, should circumstances dictate? My learned friends, in their document to us, they say that they don't know what we are talking about, or they say it's not clear. I think that's they say it's not clear where we get this notion that you must have exceptional circumstances for you to invoke. I'll find it somewhere in their heads. Well, I hope it's clear now, because in their document it says, should circumstances dictate. In other words, there must be those exceptional circumstances.
But I think Ms. Barnes accepted that, to the extent
well,
it's applicable.
she had to.
But she refers to paragraph 2 of the terms of
Yes,
reference.
no, that was after prompting by you, because it
But
was...
she's done that eventually.
No, eventually she has, but I'm simply saying in her document, until prompted by you, she said she didn't know what that means. Now, the question then becomes, I'm taking us step by step. Then we say, are there such exceptional circumstances that have been alleged? Well, obviously not, because they say they don't even have to. It's unnecessary. But to the extent that they say those exceptional circumstances are effectively the fact that this is an urgent matter that has to be resolved. I have addressed that in my main address and said firstly, all labor matters are urgent.
Your submission to me was that urgency in itself is not a circumstance.
Doesn't exist, yes. And that to prove that for any South African is to understand that the proceedings before Judge Nugent are said that they must happen speedily. So why is the urgency in this inquiry excluding oral evidence, but in front of Nugent, urgency does not exclude oral evidence? That alone is irrationality, especially if the decision is made by the same person, the president. So honestly, there's no exceptional circumstance and I read many times that your terms of reference and the code say that it must be done expeditiously and fairly, and not or. So the one doesn't negate the other. The fact that you have to do it expeditiously does not mean you must do it unfairly. The second point is very simple, which is that the code, now that we accept that this is the right code, this code then at paragraph 10 prescribes a process of cross-examination and calling of witnesses by both parties. That they can no longer be disputed now. And any departure from it must either be justified or it is unlawful. Unlawful in the sense that it departs from what the parties have legislated for themselves as what the process should be, right? So nobody can say, we've legislated that between the two of us, we will have cross-examination and calling of witnesses. But one of us just decides to somehow discard that. But we agreed. And that's why I was saying a contract has the same legal force as legislation. The only difference is that a contract legislates the relationship between the two persons involved. So there's no coming out of the fact that these two parties, Mr. Moyane and the employer, have agreed to a dispensation that allows for oral evidence and cross-examination of witnesses. Okay? So that's it. Now, and if we let's say that I'm right for a change, that there are no exceptional circumstances put before you. Such exceptional circumstances that are attempted to be put before you don't take the matter any further. They're neutral in effect. Then you have no choice, quite frankly, but to apply the consensus between the parties as expressed in the disciplinary code, which we now know applies. Okay? Now, and this is underlined by the cases that they present, Chairperson, which is that they say, for example, the Bemau case, the Bemau SABC case, excuse me, in that case, the exceptional circumstances were the fact that there were too many employees, and I think it was a strike situation, if I remember well. And the judges said, well, imagine if you are going to have, I'm making this up, I don't know how many employees, let's say 500. If you're going to have 500 different hearings, that's an exceptional circumstance. Because of the circumstances of that case, you could do this. So you can't do this without exceptional circumstances which are proven. And that's forget the law. That's what it says in their own code. Under certain circumstances, you may do this. But what I'm saying is that they are even misreading what it is that you might do under certain circumstances. Because it says under certain circumstances it must be fair and just. So it brings us back what is fair and just, which is what we're asking you to decide. And there's no answer, with the greatest respect, to quote a case that says it's not the first time that written submissions have been allowed. So it's the second time or the third time. What about the other million times that we know that everywhere across the whole country people are subjected to disciplinary hearings every day, literally? I'm
But I'm still going to decide that on this case.
Yes. No. I'm making a different point. You have to decide it, of course. I'm saying you can't answer that submission by quoting something that says it's not the first time.
But that's exactly my
Because it shows that that actually makes my point, that it's an exceptional circumstance. It's not the first time. Okay, it's the third or fourth time. But I can give you 10 million other times where it's done in the normal
But that
way.
informs my comment, Mr. Mpofu, that I've got to decide it here. The fact that it may have been done elsewhere is not precedent. I've got to make a decision on this.
I don't think you understand my submission. I'm saying, of course, that is true, but I'm saying the mere fact that the court in that case said it is not the first time, it was done in another case, Avril, emphasizes the point that it's an exceptional thing. Imagine if I said to you, it's not the first time that oral evidence is heard. You'd think I'm out of my mind, because that's what happens all the time. The exception is the other one. That's why they said in that case it's not the first time. It has happened before, once. Okay? So our case is not that it never happens under the sun. We're saying, that's why we said, in terms of criminal, that's the part they misunderstood. In criminal proceedings, it's irrefrangible. In these kinds of proceedings, it can happen in exceptional circumstances. We were emphasizing that very point here. This thing about the letter that they gave us on the 15th of May, it's irrelevant. I mean, that letter was simply a regurgitation of the terms of reference, to say that oral evidence is not excluded, however they put it. So that's why I don't take the point. I could have taken the cheap point to say, don't worry, you've said in the charge sheet that it's not allowed, therefore you've made your election. I'm not making that point. I accept that there was a bit of a retreat in the terms of reference, which was expressed in the letter of the 15th. So that doesn't take the matter any further. You can look at the letter of the 15th or the terms of reference, it's the same thing. That both of them are unlawful. And then we say, okay, I give up on this question of authority. And honestly, I just don't think that it's...
But the arguments are quite clear, unless there's anything else.
No, it's clear, but it's still a misconception that we're talking about witnesses and deposing to affidavits. No. So I'll just...
I understand your argument. Yes. I understand Ms. Barnes' argument.
Yeah, it's a rule of law argument. It's got nothing to do with the right to be a witness. But I don't think I can take it any further. And then we're told that from the bar, that you must accept the late affidavits.
That's para 3 and 5.
Yes. I mean, well, that one is not, it's both disingenuous and disrespectful, to put it bluntly. Because you can't say to this tribunal here that it must accept documents when nobody has asked you to do so. As I said, the fact that you might want to do so out of the kindness of your heart is another matter. But for this party that has said all they have said at paragraph 60 of their affidavit, they say, when we deal with this thing about affidavits, paragraph 60, we confirm that the following persons have filed confirmatory affidavits.
You say paragraph 60 of the heads
60 of their heads, yeah. We confirm that the following persons have filed affidavits. They don't say when. They don't say that they were late. They don't say all these things that we hear now. There's no prejudice and so on. You can't hear that from the bar. That must come. That should have come from those people. And then this complaint is accordingly without substance. That's an insult. So as if we made a complaint, we made that complaint on the 28th of June, when those affidavits were supposed to be with us on the 22nd of June. And only one of them has come 2 days ago. And we are told this is without substance. In other words, we are crazy. We complained about confirmatory affidavits that were in their minds. I mean, really. You can't make a submission like that and just say, at least the very least they should have disclosed to you at paragraph 60. We confirm that they've been filed late for this and that reason. We might have a different complaint. We could have said, well, they can't give evidence, it should be on oath, whatever. That's a different matter. But to just put it like this and say it's without substance, it's just really unnecessary arrogance for people who have not complied with your ruling, as it were. So it's not a small thing that can just be brushed off. Now, the last 2 points. Yes. I say my learned friend says the fact that there is an overlap is neither here nor there. I mean, do I have to respond to that? The fact that there's an overlap is the gist of the complaint. And the overlap, as I say, is acknowledged by both Mr. Nugent and the President in their submissions. And as I've already made the point that there's no need we've never asked you to disestablish anything. And by the way, now that it has come up now, we want to register to you. You can do with it what you will, Mr. Chair. That the non-production of this code in the first place is something that is suspicious, because the code is itself linked by the Godan affidavit, and then it's linked to the disciplinary code that answers the very question we have raised about oral evidence and cross-examination. And suddenly it was not produced. It's only when we saw that connection at point 3.5.1 of the code, of the Godan code, that we asked for it, and then it was produced to us. And then even here, there was a feeble attempt to say it doesn't apply, when it obviously does. So the disciplinary procedure comes back to what I was saying about the case. You have to literally hold the two documents like this and say, am I going to apply this one, or am I going to apply this one?
But I indicated earlier that may not be as binary as that.
No, of course.
I may find that I've got to interpret.
Yeah, that's on the first point. No, I accept that. We've had that debate. I don't want to go back to that debate. Yeah, but for the purposes of finding whether the first point is good or not good, it's one or the other. It's either, let's call it that, the motion proceedings which are envisaged in the terms of reference, or the trial proceedings that are envisaged.
I've already said to you why I'm not sure that it's binary, but we've had the debate already.
Yeah, we've had that debate, but I'm just emphasizing my submission. Yes. So again, the question of the parallel processes, to close off, I think is not well understood, because as I've said there, once you accept that there is that overlap, then you have to say, is it fair? Just, not even in a legal sense, just as a normal person. Is it fair that while you are facing this on this side, you are also facing, or not even facing it, but it is happening down the road? That's what I was saying. The sub judice rule, which I must confess is just an example, is meant to stop that. That's why I was saying those are rules of fairness. Because there's no reason why the press is precluded from reporting on a case that's going on. It's simply to say it's not fair for you to be expressing yourselves on the merits of a case that is still to be decided. And that fairness does not mean you, Chair, you are suddenly going to be watching on television and necessarily saying, oh, he's guilty because you see all that. It goes wider than that. It's what happens in the public mind. The fairness is a broad thing. Justice Sachs in Masetla puts it beautifully because he says that, I'm sorry. Fairness to an incumbent, a person like Mr. Moyane, that's paragraph 53 of my head. Fairness to an incumbent about to be relieved of a high-profile position in public life presupposes the display of appropriate concern for the reputational consequences. People live not by bread alone. Indeed, in the case of a career functionary, reputation and bread are often inseparable. And I would add that it was not only material benefits and the standing of the incumbent that had to be considered. The general public, too, had an interest. Constitutionally created institutions need constantly to be nurtured if they are to function well, including SARS. This requires that those who exercise public power should avoid, wherever possible, acting in a manner which may unduly disturb public confidence in the integrity of the incumbents of these institutions. In this regard, it is my view that fair dealing and civility cannot be separated. Civility in a constitutional sense involves more than just courtesy or good manners. It is one of the binding elements of a constitutional democracy. It presupposes tolerance for those with whom one disagrees and respect for the dignity of those with whom one is in dispute. Civility, closely linked to Ubuntu, Butu, is deeply rooted in traditional culture and has been widely supported as a precondition for the good functioning of contemporary democratic societies. Indeed, it was civilized dialogue in extremely difficult conditions that was the foundation of our peaceful constitutional revolution. The constitution that emerged, therefore, presupposes that public power will be exercised in a manner that is not arbitrary and not unduly disrespectful of the dignity of those adversely affected by the exercise. To the extent that any reputational damage to Mr. Masetla might have been caused by the manner in which the proceedings unfolded, the judgment in this matter established that the basis for the termination of his incumbency was simply an irretrievable breakdown of trust and not dismissal by misconduct. That distinction is very important. It makes 2 points. It's what I call the SARS standard as one of the procedural unfairness. So he adds to Section 34 and Section 9, reputational damage. In other words, you cannot have Mr. Moyane being vilified and insulted by the Godans of this world and other people in the Nugent or SARS Commission, and he must tolerate that about the very issues that overlap with what he is now facing before you. It's as simple as all that. It's civility, it's Ubuntu, it's crass not to do it. It is disrespectful of the very values of the foundations of our Constitution, which says you must respect not only those people that you agree with, but even those you disagree with. Mr. Moyane is a senior employee, a person who has collected our taxes for so many years. He cannot be treated like the way he's being treated by Mr. Godan and other people. If there is a difference, fine. But there's civility. There are ways that it can be dealt with. And one of the ways it can be dealt with is not to subject him to a kangaroo court down the road while he's facing this, which I must say for the record, this one is not a kangaroo court.
Can I really don't want to be commenting or put in a position in relation to that. Can I ask one question?
Yes.
On the overlay issue, the dual process?
Yes.
Your complaint, as I understand it, is you shouldn't have something dealt with in process A and in process B because there is a problem. Presumably, you're not suggesting that it mustn't be dealt with in either one of them.
No. Absolutely not. That's why I'm saying I don't know where this established thing comes from. No, that's not what we're saying. As I said, firstly, when we argued this point in front of Commissioner Nugent, we gave a way out. We said, you can have both processes, actually. You should just, while the disciplinary inquiry is taking place, avoid those issues that overlap. He rejected that, okay? There's nothing we can do. That will be decided by a court as to whether he was right or wrong. Now, what we're saying to you, unfortunately, you are in a more disadvantaged position than Commissioner Nugent, because, as he could say, there's the wider commission and then there's narrower one. Yours is the narrower one. So whatever you do, it's not going to make any difference, because the narrow scope of the narrow scope cannot be controlling the bigger scope, so to speak. It is he, although he eschewed that opportunity, who could have said, okay, I'm demarcating the narrower scope and then allow the BAM SC approach to continue, and then when it's finished, we can widen. You can't do that. I'm
limited.
Yeah, you're limited, because you can't say, no, this witness, Mr. Gordhan, must not go to Nugent. That would be ridiculous.
That's exactly.
So that's why we can't ask you for that same relief, and we can't ask you for any.
If I understand what you're saying, that you're saying, for so long as it is not clearly excised from the SARS Commission,
yes,
I have a difficulty.
Yes, you have.
I understood that.
Yes, you have a difficulty, but the real person who has a difficulty is Mr. Moyane, because for as long as the two processes are running together, he's going to be subjected to this process, which is legitimate, as like any employee has to face their employer. And at the same time, be faced with a kangaroo court that is run by people.
I'm going to ask Mr.
Okay, a sham hearing.
Can I just say this? I'm a bit anxious about any description of something that I can't engage myself
Yes.
in.
Well, that is, okay, I'll use...
In neutral terms,
fine.
it's the SARS
Yes,
inquiry,
yes. I'll use the dictionary term.
No.
Any process that is unfair and arbitrary, which means a kangaroo court. But, so let's use the neutral term. He cannot be subjected to any other process that is unfair and arbitrary somewhere else, where some of the people who are presiding over it are friends of the president, for example. So he can be, and as I've said earlier, even if that process was prim and proper and had no blot whatsoever, given what Judge Albisach said in this, and given what I read to you earlier in the Magidiwana case about the potential prejudice and reputations which might be harmed and so on, that even if it was the greatest, the Nugent Commission was the greatest in the world, that would still be unfair for it to continue simultaneously with this. As I say, the risk, that's why it says potential. The risk, which I'm quite sure would not eventuate, is that you, Mr. Chair, your mind would be poisoned by what is happening there. But I'm quite sure that risk won't eventuate. The other risk is that in the eyes of the general public, all the things that Mr. Sachs or Judge Sachs say would eventuate. That you have no control over, that second leg. You'd have control about your own unpoisoning of your own mind. But you cannot have control over the inherent and natural prejudice that follows from running these two things at the same time. It's really quite simple. And and therefore, there has to be an answer to that, to put it lightly. And there is none. There is no, all we are told is that, no, the other one is an inquiry, the other one is who cares? The point is that both of them are potentially prejudicial to him, and the running of them in tandem causes that prejudice. And therefore, something has to be done, not by you, but by the person who caused the crisis.
That's exactly
that is the president.
That's exactly the point.
Yes, but you have the right. You have the right to say what is fair and not fair, because you are told to do so at 3A. Is it fair? What I've just described to you now, is it fair or is it not fair? That's within your province, understand? So if you can say that is not fair, then clearly your 3A powers are being curtailed by that fact. What you cannot do is to say, I'm stopping the Nugent Commission, or I'm stopping this one. You can simply declare that to have this running together is unfair. Just as you can declare if there was the inquiry was continuing here, Chair, and I was badgering a witness and asking that witness the same question 100 times, it's within your power to say, Mr. Mpofu, that is not fair. And that's it. I can't say, no, but Chair, there's the president and all these things that were told here. It's your power to make sure that this inquiry is run on a fair basis. If anything happens, if Mr. Moyane or I come here and talk for 3 days about an irrelevant case and read a long passage or read a whole textbook, you can say, no, Mr. Mpofu, that's what you are given power to. It can be difficult.
I understand that
Yeah.
the submission is, you say I have the power in terms of the terms of reference.
To determine what's fair.
Considering those facts,
Yeah,
to determine, because I can only do so in relation to this
yes,
hearing,
absolutely.
whether it's fair for somebody to be subjected to those issues before me
Yes,
in two different forums with
Absolutely.
the danger of
yes.
conflicting findings and fact, etc.
And reputational.
And I understand the danger.
Yes. In other words, it's like if I was before a judge and I say to the judge, Judge, yesterday there was, and actually this has happened before. Yesterday there was a report in the media that suggested that my client, Mr. Moyane, did X, Y, Z, and what have you, and that was not the evidence that was led here. And the judge normally, at least in the case that I was involved in, would say to members of the press, I want to make it clear that this is unfair, this is not what I said, blah, 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 you must watch. But if the judge said, oh, no, I was appointed by the Judicial Services Commission, I can't do anything about it. What is that? It's what you call abdication of the power that you have.
In other words, you're saying that the very terms of reference permit me to pronounce.
Absolutely.
I've got it.
All right. I'm really sorry. I promise this is really the last one. No, I think I've made the point.
You won't forget to tell me about what I do on the eventual.
Oh, yes, the question that you put.
And Ms. Barnes said to me,
You're on your own.
yeah, I'm on my own.
That was
And
the
if I am, then I've got to make the finding. But,
Yes, that was our slogan, you might remember.
I know what you would say.
You are on your own.
I know what you would say, that if I'm with you on one or other of the points that would shape it.
Yes.
If I'm
Well,
against you, there's still an inquiry to go on.
Yes.
And there's still a response. I'm not going to dictate the response, but there's still a response. What do I then do, Mr. Bham?
Yes. Okay. If you are against us, then obviously you do what Commissioner Nugent does. You say, I reject all the objections, and that's the end of it. We will do what we do. But if you are with, that's if you are against us.
On that,
Yes.
remember, if I say I'm against you, this
yes.
thing still continues. I've still got to make it, because your response to the charges and the affidavit
Yes.
was this, and I'm not critical that you've raised points you're entitled to raise in law. I may find against you. Then there's still a inquiry I've got to run. Now, of course, what you may decide to do outside is not my business. My business is...
Yes. Yeah. No, absolutely. In fact, I can tell you, because it's not a secret. If you do that, in other words, you give an order that says, I'm rejecting the objections. Remember, what we did was to, and I don't know if we brought this to your attention, but I can tell you now because it's common cause. What we did on the 2nd of July was to write a letter to the President. And we said to the President, Commissioner Nugent has given this ruling. We have, coming on the 21st of July, a hearing before Chairperson Bham SC. Please find attached the objection, the Rule 653 document. And tell us what we need to do, insofar as the decisions are in your province, so that we can either go to court or whatever. The President said no, and we agreed with this. I will wait for the ruling of BAM SC. before I respond to your letter of demand, which says you must either disestablish this one or, in fact, we gave him 3 options. We said you either disestablish both commissions, or you disestablish one, or you tell us that you are continuing with all 3, and then we'll decide what to do. So he said, no, hang on. I'll wait for the ruling. Once your ruling is out, then your ruling will, and then the president used the word consider. I will then consider the ruling of BAM SC, and then I'll reply to you. So the sequence is as follows. You will give your ruling, the president will consider it, he will then come back to us. Only then can we go to court, because to do so would be premature, because the president might come and say, BAM SC was wrong, or in any event, I've rethought, I've now taken legal advice, and on the basis of Magidiwana, I think both Nugent and BAM were wrong, or one of them, or whatever combination. There are millions of.
But the answer to what I've asked
permutations.
is, I must do what I must do.
Yes.
And what
And
happens
let it
thereafter.
flow, yes.
Okay. Now,
The other answer, Chair, which is maybe will give you more comfort, is that it depends. It depends if, let's say, for argument's sake, you dismiss all the points I've raised, and the only point you uphold is that the affidavits were not, there was no
authority.
condonation application.
Oh, the condonation.
Yes. I'm narrowing it even further. Yeah. Let's assume you say that's the only good point you've made. Then clearly, even the president, one doesn't have to be a genius to say all that will need to be done would be, you might even order them to do such a condonation application, and then we all move on. And then we're back to what I said earlier. So it depends which of the points you uphold. If you uphold all 3 points, particularly, that's why I called the first point the main point. If you uphold the first point that says that it's unfair not to apply the code in these circumstances, then it's clear what's going to happen. We will run the disciplinary inquiry. But if you don't uphold that, then obviously we will do what we have to do.
So in other words, depending on how I make my findings,
and which points you uphold.
I've then got to decide what I pronounce regarding the future conduct.
Absolutely.
To the extent that I can at this stage.
Yes. But you have to make a pronouncement.
There's no
you have to
question
make a pronouncement. I mean, your pronouncement could be, I dismiss all that, I'll see you people in 2 weeks' time at the hearing, and then we'll do with it what we want.
And then you can be certain I'll deal with each of the points.
Yeah. So that's half of the answer. If you are with us, then what we and I'm using that broadly again, of course it depends on which point and so on. So put those qualifications on the side. But if you are with us that the process as it stands now is unfair, you have various options. You can either say, well, this is how it can be cured. Insofar as you can cure, for example, the overlap with the Nugent Commission. But if it's the issues of cross-examination, then you might make a particular pronouncement, and Mr. Moyane will consider it.
But I think the challenge that both of you have put to me is that how I shape moving forward depends on how I deal with each of the points.
Absolutely.
And I am on my own on that.
Yeah. No, unfortunately, that's exactly why this is the correct way, as it was said in the Matabata case. The correct way is to raise the objection, you deal with it, and then we proceed one way or the other. Because remember, your answer, forget about court, your answer would actually determine what happens next.
Yeah.
Is what happens next us giving an answering affidavit, or is what happens next the president calling his first witness? It's that simple. Thank you.
Thank you.
Could I please make 2?
Yes, of course, I told you you would be able to.
The first point is a point of clarification. I did not concede, contrary to what my colleague seems to have thought, that the SARS code is applicable. What I said was this is the SARS disciplinary code.
I understand your argument was the
to be
following.
absolutely
You said
clear.
that this is the code that
This is the
you
code.
follow through, but your argument was that
The argument
it
remains
doesn't bind
doesn't
the
apply
president.
because
I understand
this is
that, yeah.
executive power.
That's a legal argument, but I just want to make sure that the document being
Colleague
referred
appears to have misunderstood.
Yeah.
The second
I didn't
point, Chair, is
misunderstand
that
anything. I'm
paragraph
sorry.
5.1 does not, of the disciplinary code does not refer to exceptional circumstances. It gives the employer a right if the employer is of the view that circumstances warrant it in relation to senior employees to follow a different process. That is what has happened here. There's no reference to exceptional circumstances in that paragraph.
That argument I followed.
Chair, I promise
you.
you, half a second. I accept...
Mr. Mpofu's had his right of reply extensively.
I'm really not
being
going to
gagged
allow...
now?
No, I'm not going to allow people to talk past me.
Chair, please, I just want to make one thing clear, and I promise this is going to be helpful. It's not a frivolous point. Let's assume that my learned friend's point, this last point, is correct. Then, that the employer, if the employer thinks that there are exceptional circumstances, we know it is tight law that whenever the employer or anybody or even you is given such a discretion, then the fact that justify it must be put. So it doesn't help to say there's nobody in this country, not even the president, who has a discretion that's unfettered, which must be undisclosed. So even if that was correct, those exceptional factors would still have to be put up front for you to consider if they are right or wrong.
You will be alive to the fact that it's a point I debated with Ms. Barnes.
You did.
She gave me her response, and I've got to think about both of them. But that point is not past me.
Thank you.
Can I thank both parties for their argument and their assistance with their heads, their submissions in today's argument? I was a bit shocked when I heard that we're hearing today and I might give a ruling today. Of course, I'm not going to do that.
No.
I will get down to it as soon as possible. I can tell the parties that I'm sitting I'm in an arbitration this week. And if it goes on as expected for the full week, I'll start working over next weekend. If it finishes before then, I'll start working in the week. But I will
Of course.
do my level best at the very outset to send out a ruling by the middle of the following week. I'll try, of course, to do it before then, because I understand the urgency. And I'll let the parties know, through the State Attorney and through Mr. Mabuza. Thank you,
Chair. Thank you, Chair. I would like to thank you for giving the hearing and doing it on a Saturday. And we are happy that we received a fair hearing. Thank you.
Thanks to everybody.
Very, very late lunch. That will start.
Thank you.
It's called a start. It's new. I've never eaten that. The new ones you were referring to.
Yeah, 17. No, I had to change my flight. I didn't know. I'm sorry to disappoint you. Okay.
Thank you.
Okay, Mr. Mabuza, I will do the comment.